A very good evening to everyone who have joined us here today to be a part of this academic initiative. I am Sankirtana. I will be your moderator for today. I take immense pleasure in welcoming all the esteemed members of the KSBC Law Academy, distinguished advocates and lawyers, academic scholars, students, and everyone else who have joined us here today to be a part of this imperative lecture series. Today is the last and final day of the week-long lecture series. We request you to remain silent throughout the duration of the event, kindly requesting all of you to send across your questions in the chat box. After the lecture is over, some of the selected questions will be posed to our esteemed speaker by our panelist. Kindly use this amazing opportunity that you have to ask questions to our speaker. Sir, now the forum is open to you.
Yeah, very good evening to everybody. And as the moderator said, today would be the last day, so I'll really have to rush through. And our chairperson, Mr. Gautam Chand, has particularly requested me to lay some emphasis today by taking out some time about the differences between the old act and the new act and what is new. So we will at least dedicate some half an hour for that, and in the remaining half an hour, we will rush through whatever that is left out. Anyhow, major portions we have already covered, and I am going to cover today the areas which were left out yesterday, and what is left out is easily understandable, and there is no need of much labor on that. Secondly, I would request today our chairperson, Mr. Gautam Chandji, and also Harish ji, and all the other members of KSBC to take part in the closing session today after the lecture is over. So we will try to close it by 7, and kindly all the viewers and listeners for the day remain on the remain on the connect till the closing address is made. Now, yesterday we had stopped at chapter 4, chapter 3. Now, today we are on chapter 4. Um, Section 54 says proof of facts by oral evidence. Now, section 55 says very important thing, that is oral evidence to be direct. What the meaning of this is, in fact, it clearly exempts something by a hearsay witness. That means oral evidence should be a fact which could be seen. It must be the evidence of a witness who has seen something. So it cannot be somebody else saying that somebody who saw it and he told me, therefore I am telling this. This kind of evidence cannot be accepted. Of course, there is one exemption for this called res gestae. The hearsay with evidence which is in the immediate succession as an after effect of a person who has heard and seen something from somebody else, that is still accepted. To in fact make you understand res gestae, it may take a long time. I would request you to read res gestae, which is available, which is in fact kept under the act also. Uh, Sometimes in our next meeting, whenever we meet, we'll have more to talk about res gestae. And as I said, oral evidence has to be direct. Means if it is somebody who is saying that he has seen something, it should be of that person who has seen something. Somebody who says he has heard something, it should be of that particular person who has heard it. It cannot be A telling B and B telling to C. So this is what is section 55 and section 56, proof of contents of documents. Then it is easily understandable. Please read it. Then section 57 deals with primary evidence. Primary evidence means the document itself is produced for the inspection of the court. This is a bit important because, see, when you ask for an injunction, for example, before the trial court, particularly an ex parte injunction, the trial court would ask you, where are the original documents? Show me the original documents. Many of us and our lawyers, I have seen them arguing with the bench that we have to produce the original documents only at the time of marking the documents. Now, why should we produce it? Therefore, the office has raised frivolous objections. Please overrule it. Now, please note why the original documents are insisted at the time of granting an ex parte order is because whatever the ex parte order that would be granted is on the basis of the primary evidence. Primary evidence means you will have to produce, if you are relying upon particularly, for example, if you are relying upon a sale deed, you'll have to produce the sale deed so that the court looks at the sale deed, the original, this fellow has it, therefore the court will be convinced. Therefore, the primary evidence has to be the document itself. Then if the documents are executed in several parts, let us imagine there was a sale agreement, there is an addendum to sale agreement, second addendum, there is one more rectification deed, all these things have to be placed, is what the explanation 1, explanation 2 and 3 are there, where the document is executed in counterpart, each counterpart being executed by one or some of the parties only. Each counterpart is primary evidence. We have seen that documents sometimes are executed in duplicate, that the original sale deed is made, and we also take one more duplicate copy from the sub-registrar's office. So that's called as a counterpart. Or if there is a promissory note which has two portions, one is of the consideration and one is of the promise made. So either of the parts can become a primary evidence, is what it says. There are other explanations also. Please read it. So we are just rushing through today. Please excuse us for that, because we have paucity of time. Then what is secondary evidence is dealt under section 58 of Bharatiya Sakshya. Secondary evidence includes certified copies, copies made from the original, copies from or compared with the original, counterparts of documents. These are all the secondary evidences. So the thumb rule is that when you have primary evidence, please produce primary evidence, because primary evidence takes, decides your claim, decides your contentions by half of it, because the court will be prompted to accept whatever you say, because you are producing a primary evidence which are quite impeccable in nature. If you are producing a secondary evidence, the court may think that there have been a lot of instances that the secondary evidence documents being copies, certified copies, photocopies, etc., there are chances of tampering and doctoring. Therefore, as much as possible, produce the primary evidence, and the secondary evidence is what that is said under section 6058. Secondary evidence you will have to rely upon only when you don't have the primary evidence availability with you. So secondary evidence is what which is spoken under section 58. Then 59 speaks of proof of documents by primary evidence, once again directly correlates with 57. Then section 60, cases in which secondary evidence relating to the documents may be given. It says where all you can give secondary evidence in the absence of primary evidence, where all you can give secondary evidence. Then section 61, electronic or digital record. This is the new inclusion. Gautam Chand sir had asked me particularly to lay emphasis on the new inclusion. Section 61 is the new inclusion. Nothing in this Adhiniyam shall apply to deny the admissibility of an electronic or digital record in the evidence on the ground that it is an electronic record or digital record, and such record shall subject to section 63. So every electronic record now becomes an evidence. Therefore, be careful when you are sharing something on your social media, because everything which is electronically transmitted is considered a record, is considered a document, piece of evidence. Therefore, you can't simply say that it's just a pass, it's just a forward, it may not have the evidentiary value, all these things. So you'll have to come out of such perception. Now the law makes it very, very clear that even an electronic record stored digitally on any one of the devices, may it be a computer, may it be a hand phone, may it be a mobile phone, may it be a tab, or may it be even a TV recording or whatsoever, they are all considered. But one condition is subject to section 63. What is section 63? 63 is a replica of 65B of the Erstwhile Evidence Act. Section 63 says admissibility of electronic evidence, and there are certain conditions under section 63. Whenever there is an electronic evidence produced, it has to follow with certain conditions, authentication, etc., certification, and such things which are told under section 63. Please read section 63 carefully, and whenever you are using any electronic record as evidence under section 63, you will have to in fact authenticate it, you will have to probate it by the rules which are contained under section 63. Then 64 deals with rules as to the notice to produce. Secondary evidence of the contents of the documents referred to in clause E of section 60 shall not be given unless the party proposing to give such secondary evidence has previously given to the party in whose possession or power the document is, or to his advocate or to representative, such notice to produce it as is prescribed by law, and if no notice is prescribed by law, then such notice as the court consider it. So when you are producing certain secondary evidences, you will have to inform in prior. This is what section 64 says. If there is no such conditions under law that such an information is required, then the court will take the discretionary call that what all has to be followed before producing a secondary evidence in respect of a document or in respect of a record which the original is with somebody else. Then 65 speaks proof of signature and handwriting of persons alleged to have signed or written a document produced. If a document is alleged to be signed or to have been written wholly or in part by any person, the signature or handwriting of so much of the document as is alleged to be in that person's handwriting must be proved to be in his handwriting. We have seen, we generally see the documents, registered documents when they are drafted. You always put who has drafted the document. Earlier days, in all this Urdu language and all, they used to call it as Bikalam. Who is the author of the document? Who is the writer of the document? There used to be document writers, licensed document writers. So, if there is a document, a part of it or the whole of it, if it is disputed, of course, you can always bring in the person who has prepared the document as a witness, and if he is not available, you can prove his handwriting, etc., by comparing it to the contemporary documents to which he must have been the author, and it expands like that. Section 66, proof as to electronic signature. 66 is the inclusion, except in case the secure electronic signature. If the electronic signature of a subscriber is alleged to have been affixed to an electronic record, the fact of such electronic signature is the electronic signature of the subscriber must be proved. There is something called as electronic signature or digital signature, which is very, very important. Don't get confused that electronic signature means what you do a signature on a tab by using an electronic pen or something like that. Electronic signature is always in the form of an electronic code, which is specifically generated and issued to you by the digital signature or electronic signature issuing authority. You see the usage of electronic signature most in the corporate business, and when you are filing income tax returns, etc., when you want to upload certain documents to the government authorities, or when you want to apply for passport and all, these days I think electronic signature is also made a little must. Therefore, electronic signature, don't get confused it with your general signature, what you have you sign using a pen and paper on an electronic field. It is something different. It has to be issued by an appropriate authority against an appropriate application. Once it is issued, it is generally in the form of a pen drive or generally in the form of a code, which you will have to personally possess with you without divulging it to anybody. And if you give your electronic signature to somebody else's custody, then you are doing a greatest error, because by using the electronic signature, which is in the form of a pen drive or which is in the form of an electronically stored device, and then somebody can certainly misuse it. Of course, digital signature or electronic signature has got something called as a public key and a private key. Of course, that's a different subject altogether. We will deal with it whenever the time permits. For time being, section 67 deals with that. 68, proof where no attesting witness is found. Generally, we see there are attesting witnesses, especially when we are talking about the will. A Hindu will has to be authenticated by two attesting witnesses. Attesting witnesses are whom? Attesting witnesses are not exactly the witnesses to the document. Sometimes attesting witnesses are just the witnesses, not to the contents of the document, but to the execution part of the document. Therefore, if the attesting witnesses are not found, attesting witnesses are the persons who will say that such and such document was in fact executed if the document is in dispute. If the attesting witnesses are not found, how to prove that? Then you will have to resort to section 68, 69, admission of execution by a party to attested document. Also, it is in consonance and in unison with section 68 and 60. Section 68. Section 70 deals with proof when attesting witness denies the execution. So let us imagine a situation if the attesting witness says, no, I did not attest this, it's not my signature, etc., etc., then what is that something which you will have to prove? You will have to then go back to some other area. That witness, if he has attested some other document, you'll have to bring it, you'll have to show his signature, then you'll have to compare with the signature where the attestation is found, or you can go to some third persons where the attesting witness must have been present. So much of it becomes laborious. See, under evidence law, if something is admitted, there is no much labor required, there is no much work is called for. The entire law of evidence, the rules of law of evidence, Bharatiya Sakshya Adhiniyam, comes into play when there is denial. When there is denial, then you will have to go on piling up, okay, because they are denying, how to prove the part of it, how to prove a particular portion of it, etc. So the labor and additional efforts steps in when there are denials. So when there are denials, so many other provisions of the Bharatiya Saksha gets triggered. Section 71, proof of document not required by law to be attested. Whenever there is no attestation required under law, then proof of such document is not required. And 72, comparison of signature, writing or seal and others admitted or proved. Once again, straight away understandable. Please read it. Then 73, proof as to the verification of digital signature. This is something new, because of course this was there under the Information Technology Act, which was an interdependency whenever we used the Act of 1872, because Information Technology Act, we had it from 2000. So all this digital signature, electronic signature, etc., have been exclusively dealt under the Information Technology Act. Now, a lot of information technology has been imported directly into Sakshya Adhiniyam whenever the electronic record, whenever an electronic document, electronic storage, digital signature, electronic signature, etc., forms a part of evidence. Whenever it gains an evidentiary value, the Bharatiya Sakshya, in fact, incorporates all those things. So you need not to now have two books to be interdependent with the Evidence Act, the present evidence law. Bharatiya Sakshya, speaks to the proof of it. So section 73, as I told you just before, there is a certifying authority, there is a controller, etc. for the digital signature, whose role is very clearly brought out and easily understandable. I would leave it to you. Then 74 deals with public and private documents. Of course, public documents, you all know what are the public documents. It's a public document. There, in fact, a list of public documents is given. Private documents, once again, letters, personal seals, etc., would amount to private documents. So public documents are generally accepted as impeccable proofs because they're publicly maintained documents, and any kind of tampering there is generally ruled out. Then section 75 deals with certified copies of the public documents, and then the section would in fact would read a certified copy of the public document will have the same value as if it is of the original, because it is certified from a competent authority of the originality. Then 76, proof of documents by production of certified copies allowed, because you generally can produce only certified copies, especially the maps, revenue records, etc. You can't get the revenue register, or you can't get the survey register and prove it, because the survey register may have so many documents pertaining to so many different properties, different persons, so that it is a singular document that if you want to prove an extract of this, you'll have to get the certified copy and prove it. Then 77 reads with proof of other official documents. The section is very clearly, cleanly, straightly, unambiguously understandable. Please read it. 78, presumption as to the genuineness of the certified copies. So this mandates a duty upon the honorable courts to have presumption in respect of the certified copies unless and until they are disputed. Then section 79, presumption as to the documents produced as a record of evidence, etc. Whenever any document is produced before any court purporting to be a record or memorandum of evidence, or any part of the evidence given by a witness in a judicial proceeding, or before any officer authorized by law to take such evidence, or to be a statement of confession by a prisoner or accused person taken in accordance with law, and purporting to be signed by the judge or magistrate or by any such officer, the court shall presume that the document is genuine. Straight away, the section reads what it means. Section 80, presumption as to the gazettes, newspapers, and other documents. There is a slight departure under this, because earlier it had the gazettes and the newspapers of England, etc., because it was the earlier act was made during the British regime. Now I think we have left over the Gazette of London. The earlier act had something like the Official Gazette of London, Official Gazette of Colony, the dependency of the position of British Crown, etc., etc. That has become now redundant. It has been left out from 80. 81 reads as presumption as the gazettes in electronic or digital record. Now, there may be something which is coming up newly, which you all must have noticed. Even our Honorable High Court and Honorable Courts have started QR coding the copies of the judgments, copies of the records, copies of the evidence. What is a QR code? QR code is a specially and distinctly, uniquely designed identification mark. Once generated, it cannot be duplicated. So once there is a QR code, that QR code, if you scan it, it would directly access the server where the original document is stored, because that QR code is in fact tagged with the main server where the original document is stored. Therefore, once the moment it is QR coded, it is authenticated electronically. If you produce even a photocopy which has a QR code, immediately the genuinity can be compared by scanning the QR code. If the moment the QR code is scanned, if the document pops up, that means the QR code corresponding with the originally stored document. Therefore, the originality can be presumed. Subject to the other contents of the document. Sometimes there could be a situation that first page has a QR code on top of it, and what if some 2 or 3 words in the text of the document is tampered? If there is something of that kind is noticed, then that has to be challenged, and of course it will invite a lot of action under law for tampering the original records, etc., etc. So no need of being skeptical about those things, because the law takes care of the consequences of tampering or trying to alter the original document, either in its copies or whatsoever. Therefore, nothing to be worried. There is a presumption insofar as the originality is concerned once the electronic document is electronically scanned by the source authority. Section 82, then the presumption as to the maps, plans of the authority of the government. You all know what is this. 83, presumption as to the collections of laws and reports and decisions. This is also very easy. What we are reading as judgments, ILR, SCR, AIR, etc. There is a presumption as to that. Then 84, presumption as to the power of attorney. Of course, this is also straight away understandable. Once a power of attorney is produced, the presumption. See, we are dealing with presumption. Presumption means it is presumed. Presumption need not be always correct. If somebody disputes the presumption, the presumption is it is correct. If I go in front of somebody, presumption is I am Shyamsundar, senior advocate. What if somebody is duplicating me? Somebody is impersonating me, dressing like me, or making himself appear like me or look like me. So the presumption can be rebutted if the presumption is attacked. If the presumption is disputed, then the value of the presumption goes. Then the rebuttal comes in the place. If the rebuttal overrides, then the presumption goes. The originality, what exactly comes out of surfaces out of the inquiry, then that will hold the field. So far as something is not disputed, the presumption holds good. Wherever presumption is told under the Indian Evidence Act or the Bharatiya Sakshya, then it doesn't require further proof unless disputed. Therefore, if there is a presumption and it is not disputed, no need of proving it. In commercial courts and all, and in arbitrations, we see a beautiful procedure that's being adopted. The procedure is there is something called a statement of admission and denials. Given before the trial starts, the court will call upon, the tribunal will call upon, see, the plaintiff has produced such and such documents as is evidence, etc. You please file a statement that what all you are admitting, what all you are denying. So is the opportunity given to the other side. So either of the parties will have to file a statement that what are they are admitting, what all they are denying. So whatever that is admitted, it goes straight away into evidence. No need of further evidence, no need of cross-examination, no need of trying to corroborate the same, no need of further placing the proof of it whatsoever. Even if it is a handwritten letter, if it is admitted, it is admitted. So the evidence may have to be placed only in respect of the denied part of it. So therefore, the process is largely simplified. Now you don't have that for everything you will have to place evidence. Whatever that is admitted need not to be proved. Then let's go to 86. Presumption as to the electronic records as electronic signatures is also straight away understandable. Then 87. Presumption as to the electronic signature certificates. There is a presumption in respect of electronic signature certificates. Because now what is this electronic signature certificate is now, see, earlier when we all got our degrees, we all got our convocation certificates, the authority which is giving the convocation used to sign it personally. The Vice Chancellor of Bangalore University, in fact, has personally signed all our convocation certificate, because at our age we did not have all these digital certificate, digital signatures, etc. Either it used to be a facsimile signature or it used to be the original signature of the authority who was granting us the certificate. These days, let us imagine in every year, if there may be 1,000 law students passing the exams, every marks card, every certificate, it may be a physical impossibility to sign everything. Therefore, there is something called as electronic signature. And once if the electronic signature is found or a digital signature is found, there is a presumption that it is the original signature. Therefore, this part deals with that. All this something which concerns with electronic signature, all these things have been newly added into Adhiniyam. Then 88, presumption that is certified copies of the foreign judicial records. As imagine if you are in an international arbitration, some judgments of some UAE courts or Australian courts or American courts are produced. There is a presumption with respect to those judgments which are produced in the nature of judgments, and general presumption is acceptability unless and until disputed. 89, presumption as to the books, maps, and charts. The published books, maps, and charts, also there is a presumption. 90, presumption as to the electronic messages. Yeah, this is important. Now, earlier, there have been certain judgments that the forwarded messages need not to be accepted as the original, and forwarding and all need not to be considered seriously. Now, after the amendment, yes, there is something that has come in, presumption as to the electronic messages. As I told you yesterday or day before yesterday, that even if you are holding a forwarded message and the original message is unknown, destroyed, not found, still the forwarded messages are presumed to be correct unless they are disproved. Therefore, be careful. Then 91, presumption as to the due execution of the documents not produced. Then 92, presumption as to the documents of 30 years old. See, any document which is 30 years old, earlier this provision was there, it has been straight away carried into the act as it is. This corresponding provision earlier was section 90, now it is in 92. The any document which is more than 30 years old, any document which is more than 30 years old is presumed to be an ancient record, and there is a presumption of its correctness because it has spent its time. 93, presumption as to the electronic records of 5 years old. A similar provision has been introduced in respect of the physical documents. It is 30 years. In respect of the electronic documents, even if it is 5 years old, there is a presumption. We complete the chapter 4, chapter 5 with this, and chapter 6 deal with of exclusion of oral evidence by documentary evidence. What is this exclusion of oral evidence by exclusion of oral evidence by documentary evidence? The meaning is very, very simple, that if there is documentary evidence available, then the oral evidence is excluded. Oral evidence is required when the primary evidence is not available. 95 deals with exclusion of evidence of oral agreement. Exclusion of, I'll read 95 so that you'll understand the other things. When the terms of any such contract, grant, or other disposition of the property or any matter required by law to be reduced to the form of a document have been proved according to section 94, no evidence of any oral agreement or statement shall be admitted as between the parties to such instrument or their respective interest for the purpose of contradicting, varying, adding. See, if there is a original document produced, contrary to that cannot be the oral evidence. Let us imagine if there is a sale agreement which is written and signed and executed between the parties is produced. Now, to prove something contrary, you may get some other document, but not oral evidence. Oral evidence cannot override the primary evidence which is in a written form. Therefore, it excludes the oral evidence. 96, exclusion of evidence to explain or amend ambiguous document. Now, once again, if the document is ambiguous, ಒಂದೊಂದ್ಸಲ ಹೇಳ್ತಾರಲ್ಲ ಏನೇನ್ ಬರ್ದಿದ್ದಾರೆ ಅಂತ ನಮಗೆ ಗೊತ್ತಾಗಲ್ಲ. There has been an instance before the Honorable Supreme Court a couple of times. The Honorable Supreme Court, at least I know a particular occasion was in fact forced to stay the judgment of a High Court, particularly observing that we are unable to understand what exactly is the order of the Honorable High Court. Therefore, we are staying it. So, the underlying reason being the ambiguity. If something is ambiguous, then how it has to be dealt? 97 deals with it. When the language used in a document is plain in itself and when it applies to accurately to the existing facts, evidence may not be given to show that it was not meant to apply. So, if there is no ambiguity, no need of explaining. 98 deals with evidence as to the document, unmeaning in reference to the existing fact, straight away understandable, please read it. 99, evidence as to the application of language which can apply to one only of the several persons, straight away understandable, please read it. 100, evidence as to the application of the language of one or two sets of facts, of neither of which the whole correctly applies. I'll just read. When the language used applies partly to one set of the existing facts and partly to another set of existing facts, but the whole of it does not apply correctly to either, evidence may be given to show to which of two it was meant to apply. The content of the section reads it very clearly. Let's imagine a situation if there are two sets of facts, a particular document is produced, and in that a part applies to one set of facts, another part applies to another set of facts, but does not in unison apply to both the sets of facts. Then you can give evidence in respect of the part where you want to prove that it applies. This is what it says. All these kind of peculiar circumstances which as a lawyer, one or the other time you will certainly face. Earlier, less cases, less circumstances. In spite of that, the lawmakers were conscious that all these circumstances may crop up in future, one or the other day. Therefore, the Indian Evidence Act 1862 was fertilely written to meet every circumstances which they had by then experienced and every circumstances which was presupposed by then. Now, the Bharatiya Sakshya clears all the doubts, and of course, in from 1872 to 2024, we have had almost all the circumstances which the law then covered, and therefore now I'm quite sure that in the path, in the journey of our advocacy, which may last for more than half a decade, half a century, we all lawyers who are practicing on an everyday basis will certainly come across one or the other strange or peculiar circumstances which will fall under any one of these clauses. So be mindful. Please readily read it so that when you are reading a peculiar circumstances or when you are attending a peculiar circumstances, you will certainly know, yes, I had read this. There is some provision under the Bharatiya Sakshya to deal with such a situation. 101 reads evidence as to the meaning of illegible characters, etc. Once again, straight away understandable. 102, who may give evidence of agreement varying terms of the documents, understandable, straight away, please read it. 103, saving of provisions of Indian Succession Act, once again understandable directly, please read it. Now, chapter 6 deal with the burden of proof. This particular chapter, you may have to read it with greater caution because in fact, we had a question also yesterday precisely regarding the burden of proof. Now, I'll read 104. Whoever desires any court to give a judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist, and when a person is bound to prove the existence of the fact, it is said that the burden of proof lies on that person. So whoever wants the Honorable Court to believe something beyond doubt for the purpose of him taking a judgment or for the purpose of making the Honorable Court to deliver a judgment in his favor by believing his version, the burden of proving all those assertions and facts leveled lies upon the person who wants something out of the court after a particular belief, as he would create on the basis of evidence. 105, on whom the burden of proof lies. The burden of proof in a suit or a proceeding lies on the person who would fail if no evidence at all were given on either side. Very, very, cleverly drafted section. I'll read it again. The burden of proof in a suit or a proceeding lies on that person who would fail if no evidence at all were given on the other side. Let us imagine a situation. This is very, very interesting. What happens in a plaint? You go before a suit by way of filing a plaint. The defendant comes and he contests, saying that then the burden of proof of whatever the defendant denies and you would have asserted, the burden of proof is on you. And defendant comes and defendant says so many things denying your version. Then the law clearly says the burden of proof lies on somebody whose case or whose contention would fail if he doesn't prove it. Let us imagine if defendant comes and takes a contention against the plaintiff that the sale deed or the will executed or will placed by the plaintiff is forged, is falsified, etc., etc., and therefore dismiss the suit. Then the burden is on him. If he doesn't prove that it is a false will, if it is a falsified document, then he will fail. So whenever a party who asserts something, who avers something, if he doesn't give the witness of his assertions and whatever he would aver, whatever he would aver before the court, if he would fail, then the burden is on him. See how beautifully the law is designed. Illustrations are very interesting. Please read it. 106. Burden of proof as to the particular fact. The burden of proof as to any particular fact lies on the person who wishes the court to believe in its existence unless it is provided by any law, or that proof of the fact shall not lie on any particular person. If you say, a plaintiff comes and says that Taj Mahal is in Agra, then the burden of proof doesn't lie upon him because it is universally accepted that Taj Mahal is in Agra. If he says that there is a replica of Taj Mahal in Bangalore, then the burden of proof lies upon him because he has the onus to make the court believe that there is replica of Taj Mahal in Bangalore, which no one has seen as yet. So this is how the jugglery of the burden of proof goes on. Then 107, burden of proving a fact to be proved to make evidence admissible, straight away understandable. Please read it. 108, burden of proving that a case of accused comes within the exceptions. What are the exceptions? Earlier Indian Penal Code, now the Bharatiya BNS, Bharatiya Nyaya Samhita. Now it has lot of exceptions. What are those general exceptions which were there under the IPC, now which are there under the new Samhita? Are the acts committed by a person who is not mentally sound, the acts committed by a person who has been intoxicated against his will. ಬೇಕು ಅಂತ ನೀವೇ ಕುಡಿದು ಬಿಟ್ಟು ಹೋಗಿ ನಾನು ತಪ್ಪು ಮಾಡಿ ಆಮೇಲೆ ಅದರದ್ದು ಎಕ್ಸೆಪ್ಷನ್ ತಗೊಂತೀನಿ ಅಂದ್ರೆ ಆಗಲ್ಲ. ಇಂಟಾಕ್ಸಿಕೇಶನ್ ಎಕ್ಸೆಂಪ್ಷನ್ ಯಾವಾಗ ಸಿಗುತ್ತೆ ಅಂದ್ರೆ when a person who is committing the act under the intoxicated state, the intoxication should have been without against his will. ಯಾವನೋ ಬಲವಂತ ಮಾಡಿ ಬಾಟ್ಲ್ ಗಂಟ್ಲಿಗೆ ತುರ್ಕಿ ಕುಡಿಸಿದ್ದ, ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಕುಡ್ದೆ ಅವಾಗೇನೋ ತಪ್ಪು ಮಾಡ್ದೆ ಅಂತ ಹೇಳಿ ಆ ಎಕ್ಸೆಂಪ್ಷನ್ ತಗೋಬಹುದು. ಮತ್ತೆ ರೈಟ್ ಆಫ್ ಪ್ರೈವೇಟ್ ಡಿಫೆನ್ಸ್, self defense. I shot at somebody and the person was killed and I was doing it in exercise of my right of private defense. These are all the general exceptions and the general defenses that are available. Whenever in a case you plead the exemptions which are available to you under law, that you fall under that exemption is your burden. The onus lies upon you. That's what 108 reads. Read the section carefully again. 109, burden of proving a fact, especially ವಿತ್ ಇನ್ ದ ನಾಲೆಡ್ಜ್. ಇವಾಗ ಯಾರಾದ್ರೂ ಹೋಗಿ ನನಗೆ ಗೊತ್ತು ಅಂತ ಹೇಳಿದಾಗ ಅದನ್ನ ನೀವೇ ಪ್ರೂವ್ ಮಾಡಬೇಕು. ನಿಮಗೆ ಗೊತ್ತು ಅಂತ ಹೇಳೋದನ್ನ ಬೇರೆಯವ್ರ ಕಡೆಯಿಂದ ನೀವು ಪ್ರೂವ್ ಮಾಡಿಸ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. 110 ಬರ್ಡನ್ ಆಫ್ ಪ್ರೂವಿಂಗ್ ಡೆತ್ ಆಫ್ ಎ ಪರ್ಸನ್ known to have been alive within 30 years. ಯಾರು ಬದುಕಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೋ ಅವ್ರು ಮಾಡ್ಬೇಕು. ಯಾಕೆಂದ್ರೆ there is a presumption under law after some time a person is not to be seen. ಅವ್ರು ಬದುಕಿಲ್ಲ ಅಂತ ಪ್ರಿಸಂಪ್ಷನ್ ರಿಬಟ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಯಾರು ಬದುಕಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೋ ಅವ್ರು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು. ಮೊನ್ನೆ ಒಂದು ರೀಸೆಂಟ್ ಕೇಸ್ ನಾನು ಓದ್ದೆ ಯಾವುದೋ ನ್ಯೂಸ್ ಪೇಪರ್ ನಲ್ಲಿ. ಏನಂದ್ರೆ there was a lady who was allegedly killed by the in-laws, husband and in-laws. ಅವ್ರ ಮೇಲೆ there was a 302 case, and I think after 6 months the lady was seen somewhere working in a garment industry. Quite a peculiar situation. Adike, if a person is missing, not to be seen, if somebody says no, he is still alive, the burden goes upon him, because there is a presumption of a missing person for more than certain time. Generally it was 7 years anta ittu. ಈಗ ಏನಾಗಿದೆಯೋ ಸ್ವಲ್ಪ ನೋಡಿ ತಿಳ್ಕೊಳ್ಳಿ. 111 burden of proving that person is alive who has not been heard of for 7 years. ಇದನ್ನೇ ನಾನು ಈಗ ಹೇಳಿದ್ದು. Then 1112 burden of proof as to the relationship in cases of partners, landlord, tenant, principal and agent. ಯಾರಾದ್ರೂ ಬಂದು ಇವ್ರು ನಮ್ ಲ್ಯಾಂಡ್ ಲಾರ್ಡ್ ಅಥವಾ ಇವ್ರು ನಮ್ ಟೆನೆಂಟ್ ಅಂದ್ರೆ ಯಾರು ಅದನ್ನ ಹೇಳ್ತಾರೋ ಅವ್ರು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು. Burden of proof as to the ownership. Whoever asserts the ownership, he has to prove. Proof 114, proof of good faith in transaction where one party is in relation of active confidence. ಇದು ನೆನ್ನೆ ಹೇಳಿದ್ನಲ್ಲ ನಾನು, ಈ ಸೆಕ್ಶುಯಲ್ ಅಫೆನ್ಸಸ್ ನಲ್ಲೆಲ್ಲ ಇದು ಬರುತ್ತೆ ಎಲ್ಲ. ಇದು ಲಿವ್ ಇನ್ ರಿಲೇಶನ್ಶಿಪ್ ಅದು ಇದು ಅಂತ ಹೇಳಿದಾಗ ಶಿ ವಾಸ್ ಇನ್ ರಿಲೇಶನ್ಶಿಪ್ ವಿತ್ ಮೀ, ದಟ್ ಇಸ್ ದ ರೀಸನ್ ವಿ ಹ್ಯಾಡ್ ದ ಇಂಟಿಮೆಸಿ ಅಂತ ಹೇಳಿದಾಗ ಆ ರಿಲೇಶನ್ಶಿಪ್ ಆಕ್ಚುಲಿ ಇತ್ತು ಅಂತ ಪ್ರೂವ್ ಮಾಡುವಂತ ಒಂದು ಬರ್ಡನ್, ಒಂದು ಬಾಧ್ಯತೆ ಯಾರು ಅದನ್ನು ಹೇಳ್ತೀವೋ ಅವ್ರ ಮೇಲೆ ಇರುತ್ತೆ. 115 ಪ್ರಿಸಂಪ್ಷನ್ ಆಸ್ ಟು ಸರ್ಟನ್ ಅಫೆನ್ಸಸ್. ಇದನ್ನ ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು ಕೇರ್ಫುಲ್ ಆಗಿ ಓದ್ಕೊಳ್ಳಿ. ಕೆಲವು ಅಫೆನ್ಸಸ್ ಆದಾಗ ದೇರ್ ಈಸ್ ಸಮ್ ಪ್ರಿಸಂಪ್ಷನ್, ಅದನ್ನ ಸ್ವಲ್ಪ ದಯವಿಟ್ಟು ಓದ್ಕೊಳ್ಳಿ. ಅದನ್ನ ಕೆಲವೆಲ್ಲ ಓದಿದ್ರೆ ಜ್ಞಾಪಕ ಇರೋದು. 116 ಬರ್ತ್ ಡ್ಯೂರಿಂಗ್ ಮ್ಯಾರೇಜ್ ಕನ್ಕ್ಲೂಸಿವ್ ಆಫ್ ಪ್ರೂಫ್ ಆಫ್ ಲೆಜಿಟಿಮೆಸಿ. ಇದು ಸ್ವಲ್ಪ ಇಂಪಾರ್ಟೆಂಟ್. ಯಾಕೆಂದ್ರೆ ಮದುವೆ ಆದ್ಮೇಲೆ, ಒಂದು ಗಂಡು ಹೆಣ್ಣಿಗೆ ಮದುವೆ ಆದ್ಮೇಲೆ ಆ ಹೆಣ್ಣು ಡೆಲಿವರ್ ಮಾಡ್ತಕ್ಕಂಥ, ಆ ಮಹಿಳೆ ಡೆಲಿವರ್ ಮಾಡ್ತಕ್ಕಂಥ ಸಂತಾನದ ಬಗ್ಗೆ ಅದರ ಲೆಜಿಟಮೆಸಿ ಏನಿದೆ, ಆ ಲೆಜಿಟಮೆಸಿಗೆ ಒಂದು ಕನ್ಕ್ಲೂಸಿವ್ ಪ್ರೂಫ್ ಅಂದ್ರೆ ಅದು ಅವ್ರದೇ ಮಗು ಅಂತ, ಆ ವ್ಯಕ್ತಿಗಳ ನಡುವಣ ಸಂಬಂಧದಿಂದ ಜನಿಸಿದಂತ ಮಗು ಅಂತಕ್ಕಂಥ ಆ ಒಂದು ಲೆಜಿಟಮೆಸಿ ಆ ಮಗುಗೆ ಇರುತ್ತೆ. ಅದೇ ಕನ್ಕ್ಲೂಸಿವ್ ಪ್ರೂಫ್. ಮ್ಯಾರಿಟಲ್ ರಿಲೇಶನ್ಶಿಪ್ ಇದ್ರೆ ದಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ದ ಕನ್ಕ್ಲೂಸಿವ್ ಪ್ರೂಫ್. ಕನ್ಕ್ಲೂಸಿವ್ ಪ್ರೂಫ್ ಅಂದ್ರೆ ಏನಪ್ಪಾ ಅಂದ್ರೆ, the conclusive proof doesn't require any further proving at all, because it is assumed to be conclusive. ಯಾರು ಅದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. 117 presumption as to the abatement of suicide by a married woman. When a question is whether the commission of suicide by a woman has been abated by her husband or any relative or husband is shown that she has committed suicide within a period of 7 years. ಇದು ಆ 304B ಕೆಳಗಡೆ ಇರುತ್ತಲ್ಲ ಪ್ರಿಸಂಪ್ಷನ್, ಆ ಪ್ರಿಸಂಪ್ಷನ್ಗೆ ಇದು ಈಗ 304B ಏನೋ ಬೇರೆ ಸೆಕ್ಷನ್ ಚೇಂಜ್ ಆಗಿದೆ ನ್ಯಾಯ ಸಂಹಿತೆನಲ್ಲಿ, ಅದು ನೋಡ್ಕೊಳ್ಳಿ. ದಿಸ್ ಇಸ್ ವಿತ್ ರೆಸ್ಪೆಕ್ಟ್ ಟು ದ್ಯಾಟ್. ದೆನ್ ಪ್ರಿಸಂಪ್ಷನ್ ಆಸ್ ಟು ದ ಡೌರಿ ಡೆತ್. ಈ ಕಾನೂನಲ್ಲೇ ದೇರ್ ಆರ್ ಸರ್ಟನ್ ಪ್ರಿಸಂಪ್ಷನ್ಸ್. ಇಫ್ ಇಟ್ ಇಸ್ ವಿತಿನ್ 7 years it has to be presumed and called as dowry death ಅಂದ್ರೆ there is a presumption. You have to rebut it. Unless you rebut it, the court has to presume it. 119 court may presume the existence of certain facts. ಕೆಲವೆಲ್ಲ ಕೋರ್ಟ್ ಪ್ರೆಸ್ಯೂಮ್ ಮಾಡ್ಕೊಳ್ಳೇಬೇಕು ಅಂತ ಇದೆ, ಯಾರು ಹೇಳ್ದೆ ಹೋಗ್ಲಿ. ಅದು ಒಂದು ದೊಡ್ಡ ಲಿಸ್ಟೇ ಇದೆ ಈ ಸೆಕ್ಷನ್ ಕೆಳಗಡೆ. ದಟ್ ಈಸ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 119. ಪ್ಲೀಸ್ ರೀಡ್ ಇಟ್ ಕೇರ್ಫುಲಿ. ಆ ಪ್ರೆಸಂಪ್ಷನ್ ಇದ್ದಾಗ ನೀವು ಬೇರೆ ಏನಾದರೂ ಅಲ್ಲಿ ಹೇಳುವಾಗ ಹೋಗಿ ಅದರ ಒಂದು ಬಾಧ್ಯತೆ ಪ್ರಿಸಂಪ್ಷನ್ ಅನ್ನ ರಿಬಟ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ತುಂಬಾ ಅಗಾಧವಾಗಿರ್ತದೆ. therefore you will have to take a lot of efforts on that, and you will have to place properly admissible documents. 120 presumption as to the absence of consent in certain prosecution for rape. ಇದನ್ನು ಓದ್ಕೊಳ್ಳಿ, ಗೊತ್ತಾಗುತ್ತೆ. ಮತ್ತೆ 121 ಡೀಲ್ಸ್ ವಿತ್ ಎಸ್ಟೋಪಲ್, ವಾಗ್ಬಂಧನ ಸಿದ್ಧಾಂತ. ನೆನ್ನೆ ಹೇಳಿದ್ದೀನಿ ನಿಮಗೆ ವಾಗ್ಬಂಧನ ಸಿದ್ಧಾಂತ ಅಂತ ಹೇಳಿ. ದೆನ್ 122 123 ಡೀಲ್ಸ್ ವಿತ್ exemptions. 124 chapter 9 is very important, which deals with who may testify. ಯಾರ್ಯಾರೆಲ್ಲ ಸಾಕ್ಷ್ಯ ನುಡಿಬಹುದು, who all can become witnesses. ಬಹಳ ಕ್ಲಿಯರ್ ಆಗಿದೆ ಯಾರ್ಯಾರೆಲ್ಲ ವಿಟ್ನೆಸಸ್ ಹೇಳ್ಬೋದು ಅಂತ. ಅದನ್ನೊಂದ್ಸಲ ಓದ್ಕೊಳ್ಳಿ. ಅವಾಗ ಬೇರೆ ಯಾರನ್ನಾದ್ರೂ ವಿಟ್ನೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕೋರ್ಟ್ ಬಿಡಲ್ಲ ಅಂದಾಗ ನೀವು ಅದನ್ನ ಹೇಳ್ಬೋದು. ನಾನೊಂದ್ಸಲ ಓದ್ಬಿಡ್ತೀನಿ ಫಾರ್ ಯುವರ್ ರೆಡಿ ರೆಫರೆನ್ಸ್. ಆಲ್ ಪರ್ಸನ್ ಶೆಲ್ ಬಿ ಕಂಪೆಟೆಂಟ್ ಟು ಟೆಸ್ಟಿಫೈ unless the court considered that they are prevented from understanding the questions put to them or from giving rational answers as to those questions by tender years, extreme old age, disease, whether or body or mind, or any other cause of same kind. ಚಿಕ್ಕ ಮಗು ಸಹ ವಿಟ್ನೆಸ್ ಆಗ್ಬೋದು ಕೋರ್ಟ್ನಲ್ಲಿ, ಯಾರು ಬೇಕಿದ್ರು ವಿಟ್ನೆಸ್ ಆಗ್ಬೋದು. ಆದರೆ ಕೋರ್ಟು, ಆನರಬಲ್ ಕೋರ್ಟ್ ಮೇ consider them that they cannot become witnesses for certain things. ಈ ಇಡಿಯಟ್ ಅಂತ ಕರಿತೀವಿ ನಾವು, ಕಾನೂನಲ್ಲೂ ಆ ಪದ ಉಪಯೋಗದಲ್ಲಿದೆ. ಅಂದ್ರೆ ಅವನಿಗೆ ಏನು ಮಾವಿನ ಮರ ಅಂದ್ರೆ ಅವನೇನೋ ಹಲಸಿನ ಮರ ಅಂತಾನೆ, ಏನು ಅಂತ ಗೊತ್ತಿರೋದಿಲ್ಲ ಅವನಿಗೆ. ಅಂತವ್ರನ್ನ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಕ್ ಆಗದೆ ಇರುವಂತ ಜನನ, ಕೆಲವರಿಗೆ ಈ ಆಮ್ನೇಷಿಯಾ, ಈ ಡೆಮ್ನೇಷಿಯಾ, ಡೆಲ್ಯೂಷನ್ಸು, ಹ್ಯಾಲ್ಯೂಸಿನೇಷನ್ಸ್ ಏನೇ ಮಾನಸಿಕ ಸ್ಥಿತಿ ಸರಿ ಇಲ್ಲದೆ ಇರ್ತಕ್ಕಂಥ ವ್ಯಕ್ತಿಗಳು, ಲುನಾಟಿಕ್ ಪರ್ಸನ್ಸ್, ಓಲ್ಡ್ ಏಜ್ ಆಗಿ ಸೆನೈಲಿಟಿ ಬಂದಿರ್ತಕ್ಕಂಥವ್ರು, ಏನ್ ಹೇಳಿದ್ರು ಕಾಂಪ್ರಹೆಂಡ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಏನೋ ಹೇಳಿದ್ರೆ ಏನೋ ಅಂತಾರೆ, ಊಟ ಆಯ್ತಾ ಅಂತ ಕೇಳಿದ್ರೆ ಇನ್ನ ಈಗ ತಾನೇ ಬಂದೆ ಅಂತಾರೆ. ಮತ್ತೆ ಫಿಸಿಕಲ್ ಡಿಸಬಿಲಿಟೀಸ್ ಇರ್ತಕ್ಕಂಥದ್ದು, ಈಗ ಕೇಳಿಸ್ಕೊಳಕ್ ಆಗದೆ ಕ್ಯೂಡ್ರನ್ನ ನೀವ್ ಏನ್ ತಗೊಂಬಂದು ವಿಟ್ನೆಸ್ ಅಂತ ಮಾಡ್ತೀರಿ, ಕೇಳಿಸ್ಕೊಂಡು ಹೇಳ್ತಕ್ಕಂಥ. ಹಾಗಾಗಿ ಕೆಲವು ಫಿಸಿಕಲ್ ಡಿಸಬಿಲಿಟೀಸ್ ಇರ್ಬೋದು, ಅಥವಾ ಮೆಂಟಲ್ ಡಿಸಬಿಲಿಟೀಸ್ ಇರ್ಬೋದು, ಅಥವಾ ಅರ್ಥ ಮಾಡ್ಕೊಳಕ್ ಆಗದೆ ಇರೋದು ಲ್ಯೂನಸಿ ಇರ್ಬೋದು, ಪುಟ್ಟ ಮಕ್ಳಿರ್ಬೋದು, ಏನು ಅಂತ ಅರ್ಥ. ಈ ಕೆಲವು ಕ್ಯಾಟಗರಿಯ ವ್ಯಕ್ತಿಗಳನ್ನ ಒಂದೊಂದ್ಸಲ ವಿಟ್ನೆಸ್ ಆಗ್ಲಿಕ್ಕೆ ಮಾಡ್ಲಿಕ್ಕೆ ಕೋರ್ಟ್ ಒಪ್ಪಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಬಿಕಾಸ್ ಆಫ್ ದೇರ್ ಡಿಸಬಿಲಿಟಿ. ಅದಕ್ಕೋಸ್ಕರ ನೀವು ಬೇಸಿಕಲಿ ವಾಟ್ ಒನ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್, ಹೂ ಈಸ್ ಎ ವಿಟ್ನೆಸ್. ಎ ವಿಟ್ನೆಸ್ ಇಸ್ ಎ ಪರ್ಸನ್ ಹೂ ಈಸ್ ಕಂಪೆಟೆಂಟ್ ಟು ಡಿಪೋಸ್ ಟು ಸರ್ಟನ್ ಫ್ಯಾಕ್ಟ್ಸ್. ಹಿ ಈಸ್ ದ ವಿಟ್ನೆಸ್. That fellow doesn't even have competency to say, then he cannot become a witness. Then 125, witness unable to communicate verbally. ಒಂದೊಂದ್ಸಲ ಪಾಪ ಮಾತು ಬರ್ದೇ ಇರೋರು, ತೊದಲ್ತಕ್ಕಂಥವ್ರು, ಆತರ ಸ್ಟ್ಯಾಮ್ರಿಂಗ್ ಇರ್ತಕ್ಕಂಥವ್ರು, ಕೋರ್ಟ್ನ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿ, ಲ್ಯಾಂಗ್ವೇಜ್ ಗೊತ್ತಿಲ್ಲದೆ ಇರ್ತಕ್ಕಂಥವ್ರು, ಕೋರ್ಟ್ಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲದೆ ಇರ್ತಕ್ಕಂಥವ್ರು, ಆ ತರದವ್ರನ್ನ ಹೇಗೆ ಇದು ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಅದು 125 ಕೆಳಗಡೆ ಹೇಳಿದೆ. ದಯವಿಟ್ಟು ಓದ್ಕೊಳ್ಳಿ. 126, competency of husband and wife as witnesses in certain cases. In all civil proceedings, the parties to the suit and the husband or wife of any party to the suit shall be competent witnesses. ಗಂಡ ಹೆಂಡತಿ ಕಂಪಿಟೆಂಟ್ ವಿಟ್ನೆಸಸ್ ಆಗ್ತಾರೆ. ಕ್ವಶನ್ ಕೇಳಬೇಡಿ ಡೈವೋರ್ಸ್ ಆದ್ಮೇಲೆ ಏನಾಗುತ್ತೆ ಅಂತ. ಡೈವೋರ್ಸ್ ಆದ್ಮೇಲೆ ಅವ್ರು ಗಂಡ ಹೆಂಡತಿಯಾಗಿ ಉಳಿದಿರಲ್ಲ, ಹಾಗಾಗಿ ಗಂಡ ಹೆಂಡತಿ ಕಂಪಿಟೆಂಟ್ ವಿಟ್ನೆಸ್ ಆಗಲ್ಲ. ಬಟ್ ಮುಸ್ಲಿಂ ಲಾನಲ್ಲಿ ಡೈವೋರ್ಸ್ ಯಾವಾಗ ಕಂಪ್ಲೀಟ್ ಆಗುತ್ತೆ, ಇದ್ದತ್ ಕಂಪ್ಲೀಟ್ ಆದ್ಮೇಲೆ. ಸೊ ಹಾಗಾಗಿ ದೇರ್ ಮೇ ಬಿ ಸಮ್ ಎಕ್ಸೆಪ್ಷನ್ಸ್. ಓದ್ಕೊಳ್ಳಿ, ಸ್ವಲ್ಪ ಕೇಸ್ ಕ್ಲಾಸ್ ಎಲ್ಲ ಇರುತ್ತೆ ಅದ್ರ ಬಗ್ಗೆ. 127 ಡೀಲ್ಸ್ ವಿತ್, ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ಲಿ, ಜಡ್ಜಸ್ ಅಂಡ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್. No judge or magistrate shall, except upon the special order of some court to which he is subordinate, be compelled to answer any question as to his own conduct in court, or as such judge or magistrate, or as to anything which came to his knowledge in the court as such judge or magistrate, but he may be examined as to the other matters which occurred in his presence while he was so acting. 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. ತಾವೆಲ್ಲ ತಿಳ್ಕೊಂಡಿರ್ಬೋದು, ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಸಾಹೇಬ್ರು ಕೆಲವು ಕೇಸ್ಗಳಲ್ಲಿ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. ಒಬ್ಬ ಸಾಕ್ಷಿ ಅಥವಾ ಒಬ್ಬ ವಿಕ್ಟಿಮು ಅಥವಾ ಒಬ್ಬ ಆಪಾದಿತ ಹೇಳಿದಂತ ಹೇಳಿಕೆಯನ್ನ ಜುಡಿಷಿಯಲ್ ಆಗಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೆ. 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಸಾಹೇಬರು ರೆಕಾರ್ಡ್ ಮಾಡ್ತಾರೋ ಅವ್ರು ವಿಟ್ನೆಸ್ ಆಗ್ಬೋದು ಕೋರ್ಟ್ ನಲ್ಲಿ, ಅವ್ರು ನೀವು ಕರಿಬಹುದು ವಿಟ್ನೆಸ್ ಆಗಿ. ಬಟ್ ಕೆಲವು ಸಲ ಅವರು ಕೋರ್ಟ್ ಸೆಷನ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ಆ ಕೋರ್ಟ್ ನಲ್ಲಿ ಏನಾಯ್ತು ಅವುಗಳಿಗೆಲ್ಲ ಅವ್ರನ್ನ ನೀವು ವಿಟ್ನೆಸ್ ಆಗಿ ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ಲ. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಇವಾಗ ಕೆಲವು ಸಲ ಕೋರ್ಟ್ ರೂಮ್ ನಲ್ಲಿ ಗಲಾಟೆ ಆಗಿಬಿಡುತ್ತೆ. ಆ ತರ ಬಹಳಷ್ಟು ಇನ್ಸಿಡೆಂಟ್ ನಡೆದಿದ್ದಾವೆ. ಅದ್ಯಾರೋ ಆ ತಿಗ್ಲರ್ಪೇಟೆ ಗೋಪಿ ಅನ್ನೋರ್ ಕೇಸ್ ನಲ್ಲಿ ಕೋರ್ಟ್ ರೂಮ್ ನಲ್ಲಿ ಜಡ್ಜ್ ಸಾಹೇಬ್ರ ಮುಂದೆ ಅವ್ರ ಮೇಲೆ ಹಲ್ಲೆ ಆಯ್ತು. ಆ ಸಂದರ್ಭಗಳಲ್ಲಿ ಅವರು ಜಡ್ಜ್ ಆಗಲ್ಲ, ಆ ಒಂದು ಇನ್ಸಿಡೆಂಟ್ಗೆ ವಿಟ್ನೆಸ್ ಆಗಿ ಬಾಧ್ಯರಾಗ್ತಾರೆ. ಸೊ ಹಾಗಾಗಿ ಕೆಲವು ಟೈಮ್ ನಲ್ಲಿ ಅವ್ರನ್ನ ವಿಟ್ನೆಸ್ ಆಗಿ ಪರಿಗಣಿಸಬಹುದೇ ವಿನಃ ಜಡ್ಜ್ಗಳನ್ನ, ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಸಾಹೇಬ್ರುಗಳನ್ನ ಆದ್ರೆ ಅವ್ರ ಕೋರ್ಟ್ ರೂಮ್ ನಲ್ಲಿ ಇವತ್ತು ನಿಮ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಎಷ್ಟನೇ ನಂಬರ್ ಕೇಸ್ ಯಾವಾಗ ಕೂಗಿದ್ರಿ, ಆ ಕೋರ್ಟ್ ನಲ್ಲಿ ಏನೇನಾಯ್ತು, ನೀವೇನು ಆರ್ಡರ್ ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ರಿ ಅಂತ ಹೇಳಿ ಆ ವಿಷಯಗಳಿಗೋಸ್ಕರ ಅವ್ರನ್ನ ನೀವು ಕಂಪಲ್ಸಿವ್ ಆಗಿ ವಿಟ್ನೆಸ್ ಆಗಿ ಮಾಡಕ್ಕೆ ಬರಲ್ಲ ಅಂತ 127 ಹೇಳುತ್ತೆ. ಆ ತರ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕದಂತ ಮಹಾಸ್ವಾಮಿಗಳು ಸಹ ಇದ್ದಾರೆ, ಇನ್ಸಿಡೆಂಟ್ಸ್ ಆಗಿದ್ದಾವೆ. ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಮಾಡೋರಿಗೆ, ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ ಮಾಡೋರಿಗೆ ಇವುಗಳೆಲ್ಲ ಗೊತ್ತಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರನೇ ಈ ತರ ಒಂದು ಪ್ರಾವಿಷನ್ ಇಟ್ಟಿದ್ದಾರೆ. ಆರ್ಡರ್ ಹೆಂಗ್ ಪಾಸ್ ಮಾಡಿದ್ರು ಕೇಳಿ, ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಅವ್ರು ಹೆಂಗ್ ಹೇಳಿದ್ರು ಹೇಳಿ ಅಂತ ಎಲ್ಲ ಹೇಳಿ ಅವ್ರ ಮೇಲೆ ಸಾಕ್ಷಿ ಕರೀರಿ ಅಂತ ಹೇಳುವಂತ ಪ್ರಸಂಗಗಳು ಇದ್ದಾವೆ. ಇನ್ಫ್ಯಾಕ್ಟ್ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್ ಈಸ್ ಎ ಪೆಕ್ಯೂಲಿಯರ್ ಆನಿಮಲ್. ಬಿಕಾಸ್ he is a peculiar animal, peculiarities are expected to be there. Then 128 communications during the marriage. ಇದನ್ನು ಓದ್ಕೊಳ್ಳಿ, ಸ್ಟ್ರೈಟ್ ಅವೇ ಅರ್ಥ ಆಗುತ್ತೆ. 129 evidence as to the affairs of state, straight away ಅರ್ಥ ಆಗುತ್ತೆ. 130 official communications, no need to explain. 131 information as to the commission of offenses. This is of course read with the complaint ಕೊಡೋದು ಅದು ಇದು ಅಂತ ಹೇಳ್ತೀವಲ್ಲ ಅದು. ಇದರಲ್ಲಿ ರೆವಿನ್ಯೂ ಆಫೀಸರ್ಸ್ ಅವ್ರನ್ನ ವಿಟ್ನೆಸ್ ಆಗಿ ನೀವು ಕಂಪಲ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳುತ್ತೆ, ಓದ್ಕೊಳ್ಳಿ ದಯವಿಟ್ಟು. ದೆನ್ 132 ಈಸ್ ಪ್ರೊಫೆಷನಲ್ ಕಮ್ಯುನಿಕೇಶನ್ಸ್ ವಿಚ್ ಇಸ್ ಗ್ರೇಟ್ಲಿ ಅಪ್ಲಿಕಬಲ್ ಟು ದ ಲಾಯರ್ಸ್. ಪ್ರೊಫೆಷನಲ್ ಕಮ್ಯುನಿಕೇಶನ್ಸ್ ಅವು ಇವು ಏನಾದ್ರು ಆಗಿದ್ದಾಗ, ಪ್ರಿವಿಲೇಜ್ಡ್ ಕಮ್ಯುನಿಕೇಶನ್ಸ್ ಇದ್ದಾಗ ಅವುಗಳನ್ನ ಕಂಪೆಲ್ ಮಾಡೋ ಹಾಗಿಲ್ಲ, ಪ್ರಿವಿಲೇಜ್ಡ್ ಇನ್ಫಾರ್ಮೇಶನ್ಸ್ ನ ಕಂಪೆಲ್ ಮಾಡೋ ಹಾಗಿಲ್ಲ ಅಂತ ಹೇಳುತ್ತೆ. ಬಟ್ ದ ಎಕ್ಸೆಂಪ್ಷನ್ ಈಸ್ ದಟ್ ಇಫ್ ಇಟ್ ಈಸ್ the privileged communication itself is for an illegal purpose, for the purpose of crime, then they are not exempted. Yesterday also I have explained to you about the same. Please read section 132. As lawyers we all will have to read this because we are all professionals. Then we can't simply come and say 132 of the Evidence Act read with so and so section of the Advocates Act protects us anta. Protection is only with respect to those particular privileged information which are non-inculpating, which are not illegal, which are not incriminating, which does not concern with any wrongdoing. Only those communications are protected. ಅದು ಬಿಟ್ಟು ಯಾರೋ ಒಬ್ಬ ನಾನು ಮರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ ಅಂತ ಬಂದು ನಿಮ್ಗೆ ಹೇಳಿ ಅದನ್ನ ನೀವೇ ಪ್ರಿವಿಲೇಜ್ಡ್ ಕಮ್ಯುನಿಕೇಶನ್ ನಾನು ಹೇಳಕ್ಕಾಗಲ್ಲ ಅಂತ ಹೇಳುವಾಗಿಲ್ಲ, ದೇ ಕೆನಾಟ್ ಬಿ ಎಕ್ಸೆಂಪ್ಷನ್. ದೆನ್ 133 ಪ್ರಿವಿಲೇಜ್ ನಾಟ್ ವೇವ್ಡ್ ಬೈ ವಾಲಂಟಿಯರಿಂಗ್ ಎವಿಡೆನ್ಸ್. ಈಸಿಯಾಗಿ ಅರ್ಥ ಆಗುತ್ತೆ, ಓದ್ಕೊಳ್ಳಿ. Then 134 confidential communications with legal advisor. ಇದೇ ಪರ್ಟಿಕ್ಯುಲರ್ ಆಗಿ ಅವಾಗಲೇ ಹೇಳಿದ್ ನಾನು, ಇವೆಲ್ಲ ಒಂದೇ ತರ ಇರ್ತವೆ ಸೆಕ್ಷನ್ಸ್, ಬಟ್ ಪ್ರೊಫೆಷನಲ್ಸ್ ಇವು ಕ್ಯಾಟಗರೀಸ್ ಡಿಫ್ರೆಂಟ್ ಇರ್ತವೆ. 134 is directly concerns with lawyers, legal advisors ಅಂತ ಇದೆ ನೋಡಿ. Then 135 production of title deeds of witness not a party. ಇದು ಸೆಕ್ಷನ್ 91 ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಹಾಕಿ ಕರಿತಿರಲ್ಲ, ತಗೊಂಬರಕ್ಕೆ ಹೇಳಿ ಅವ್ರನ್ನ ಅದನ್ನ ಇದನ್ನ ಅಂತ, ಅದು ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಉಪಯೋಗಿಸ್ಬೋದು, ಯಾವ ಸಂದರ್ಭದಲ್ಲಿ ಉಪಯೋಗಿಸಬಾರ್ದು ಅಂತ ಯಾರ ಹತ್ರನೋ ಇರುತ್ತೆ ಟೈಟಲ್ ಡೀಡು, ನಿಮಗೆ ಗೊತ್ತಿರಲ್ಲ. ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಇಂಥವ್ರ ಹತ್ರ ಇಂಥ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ, ಅದು ನನ್ನ ಕೇಸ್ಗೆ ಯಾವುದೋ ಒಂದು ಕಾರಣಕ್ಕೋಸ್ಕರ ಬೇಕಾಗುತ್ತೆ, ದಯವಿಟ್ಟು ತಗೊಂಬನ್ನಿ, ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು ನಾನು ಅದನ್ನೇನೋ ಅದನ್ನ ಯೂಸ್ ಮಾಡ್ಕೊಂಡು ಅಂತ ಸಮನ್ ಮಾಡ್ತಿರಲ್ಲ. ಇಂಥ ಬ್ಯಾಂಕಲ್ಲಿ ಇಂಥ ರಿಜಿಸ್ಟರ್ ಇದೆ ತರಿಸಿ, ಇಂಥವ್ರ ಹತ್ರ ಇಂಥ ಸೇಲ್ ಡೀಡ್ ಕಾಪಿ ಇದೆ ತರಿಸಿ ಅಂತ, ಅದ್ರ ಬಗ್ಗೆ ಈ ಸೆಕ್ಷನ್ ಹೇಳುತ್ತೆ. 137 witness not excused from answering on the ground of answer will incriminate. ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್ ಇದು. ಏನಪ್ಪಾ ಅಂದ್ರೆ, you are putting certain questions to the witness cannot say that if he answers that will incriminate him. ಅಂದ್ರೆ ಅವನನ್ನ ಯಾವುದೋ ಒಂದು ತಪ್ಪಕ್ಕೆ ಸಿಗಾಕ್ಸುತ್ತೆ ಅಂತ, ಯಾವುದೋ ಒಂದು ವಿಟ್ನೆಸ್, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಒಂದು ಕ್ವಶನ್ ಕೇಳ್ತಾ ಇರ್ತೀರಿ, ಯು ಮೇ ಬಿ ಆಸ್ಕಿಂಗ್ ಎ ಕ್ವಶನ್ ಟು ಎ ಪರ್ಟಿಕ್ಯುಲರ್ ವಿಟ್ನೆಸ್ ಸೇಯಿಂಗ್ ದಟ್ ಸಿ ಆನ್ ದಟ್ ಡೇ when this crime was happening, please tell you are also present there smoking ganja, am I not correct ಅಂತ ಒಂದು ಕ್ವಶನ್ ಕೇಳ್ತೀರಾ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. ಅವನೇನಾದ್ರೂ ಅದಕ್ಕೆ if he answers that there is a suggestion in it that he was smoking ganja and smoking ganja is an offense, then he cannot say that I will not answer this because it will prone me, it will expose me to an incrimination, an inculpation ಅನ್ನೋ ಒಂದೇ ಒಂದು ಕಾರಣಕ್ಕೆ he cannot say that I will not answer. That particular protection which is under section 20 under article 20 of the constitution, that no one can be compelled to be a witness against him, is available only in a case where somebody is an accused. ಅವನು ಅಕ್ಯೂಸ್ಡ್ ಆಗಿದ್ದಾಗ ಅವನನ್ನೇ ಅವನ ವಿರುದ್ಧ ಸಾಕ್ಷಿ ಹೇಳಿ ಅಂತ ಹೇಳಲಿಕ್ಕಾಗಲ್ಲ. ದಟ್ ಇಸ್ ದ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಪ್ರೊಟೆಕ್ಷನ್. ಅದು ಬಿಟ್ಟು ಈ 137 ಅಲ್ಲಿ ಈ ತರ ನಾನೇನಾದ್ರೂ ಉತ್ತರ ಕೊಟ್ಬಿಟ್ರೆ ಅದನ್ನ ನನ್ನ ಮೇಲೇನೋ ಒಂದು ಕಂಠಾಚಾರ ತರುತ್ತೆ ಅನ್ನೋ ಒಂದು ಕಾರಣಕ್ಕೋಸ್ಕರ ನಾನು ಉತ್ತರ ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ಬರಲ್ಲ. ಆಮೇಲೆ 138 is accomplice, 139 is number of witnesses, etc. Then chapter 10 deals with examination of witnesses. ಇದನ್ನ ನಾನು ನಿಮ್ಗೆ ಎಷ್ಟೇ ಹೇಳಿದ್ರು ಸಹ ತಾವು ದಯವಿಟ್ಟು ಇದನ್ನ ಓದ್ಕೋಬೇಕು. ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಆರ್ ಲಾಯರ್ಸ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ರೀಡ್ ಇಟ್ ಕೇರ್ಫುಲಿ, ಬಿಕಾಸ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ನಾವು ಯಾವಾಗ ವಿಟ್ನೆಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ವಿಟ್ನೆಸಸ್ ಯಾವ ಆರ್ಡರ್ ನಲ್ಲಿ ಆಗಬೇಕು ಅಂತ. ಮೊದಲು ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್, ಫಸ್ಟ್ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿಕಮ್ ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್. Then after the chief examination, during the course of chief examination happens marking of documents, identification of documents, making the documents a part of your oral evidence, exhibits anta mark madodu. After the chief examination there is cross examination. After cross examination there is re-examination. What is the scope of re-examination is well explained by the Honorable Supreme Court in Catena of Judgments. It says re-examination can be done by the opposite party, that is the party who has given the principal evidence, only if there is some ambiguity, and the re-examination questions cannot be simply asked, it has to be allowed by the court. 143 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಯಾವ ತರ ಆಗಬೇಕು ಅಂತ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಫ್ ಎ ಪರ್ಸನ್ ಕಾಲ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ಎ ಡಾಕ್ಯುಮೆಂಟ್. ಇದನ್ನು ಓದ್ಕೊಳ್ಳಿ, ಬಹಳ ಈ ಚಾಪ್ಟರ್ ಬಹಳ ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗಿ ನೀವು ಓದ್ಬೇಕು. ಯಾವ್ದನ್ನ, ಈ ಒಂದು ಚಾಪ್ಟರ್ ಇದೆಯಲ್ಲ, ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ಚಾಪ್ಟರ್ 10, ಇದು ಕೋರ್ಟ್ ನಲ್ಲಿ ಎವ್ರಿ ಡೇ ವಿ ಆರ್ ಯೂಸಿಂಗ್ ದಿಸ್, ಬಿಕಾಸ್ ದಿಸ್ ಇಸ್ ಬೇಸ್ಡ್ ಅಪಾನ್ ದಿಸ್ ಚಾಪ್ಟರ್ 10 ಓನ್ಲಿ ವಿ ಆರ್ ಕಾಲಿಂಗ್ ವಿಟ್ನೆಸಸ್, ವಾಟ್ ಹ್ಯಾಸ್ ಟು ಹ್ಯಾಪನ್, ಹೌ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡನ್. ಸುಮ್ಮನೆ ಗೊತ್ತಿಲ್ದಂಗೆ ಬಾಯಿಗೆ ಬಂದಿರೋ ಕ್ವಶನ್ಗಳು ಕೇಳೋದು, ಯಾವುದೋ ವಿಟ್ನೆಸ್ ನಡೀತಾ ಇರೋವಾಗ ಯಾರನ್ನೋ ಸಮನ್ ಮಾಡೋದು, ಇವೆಲ್ಲ ಮಾಡಕ್ ಹೋಗ್ಬಾರ್ದು, ನಗೆಪಾಟ್ಲಿಗೆ ಈಡಾಗ್ತೀವಿ. ಹಾಗಾಗಿ ಪ್ಲೀಸ್ ಇದನ್ನ ಬಹಳ ಡಿಟೈಲ್ ಆಗಿ ಓದ್ಕೋಬೇಕು ಎಲ್ಲ ನಮ್ಮ ವಕೀಲರು. ನಾನು ಸಹ ಓದ್ಕೋಬೇಕು, ಮತ್ತೆ ಓದ್ಕೋಬೇಕು. ನೋಬಡಿ ಕ್ಯಾನ್ ಸೇ ದಟ್ ಐ ಹ್ಯಾವ್ ರೆಡ್ ಇಟ್, ಇಟ್ಸ್ ಮೋರ್ ದನ್ ಎನಫ್ ಅಂತ, ಬಿಕಾಸ್ reading again and again only equips us better and better. Reading again and again doesn't make us inferior on the count that I have not understood, therefore I am reading it again. Every time you read, you understand better. It's like a tea code. As and when it starts aging, it gets more valuable and more garthi. Then 143 order of examination, 144 cross examination of a person called to produce a document. Cross examination ಯಾರನ್ನ ಮಾಡ್ತೀವಿ ಜನರಲ್ ಆಗಿ ನಾವು, ಯಾರಾದ್ರೂ ಒಬ್ಬ ಪಾರ್ಟಿ ಒಬ್ಬ ವಿಟ್ನೆಸ್ ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ, ಅವರ ಸಾಕ್ಷ್ಯವನ್ನ ಕೋರ್ಟ್ ಮುಂದೆ ಇಡ್ತಾರೆ, ಅವ್ರನ್ನ ನಾವು ಅಪೋಸಿಟ್ ಪಾರ್ಟಿಯಾಗಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ತೀವಿ. ಒಂದೊಂದ್ಸಲ ನೀವ್ ಯಾವ್ದೋ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಕರಿತೀರಿ, ಬನ್ರಿ ಇಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ತಗೊಂಬನ್ರಿ ಅಂತ ನೀವೇ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಕರ್ಸಿರ್ತೀರಿ. ಯು ವುಡ್ ಹ್ಯಾವ್ ಕಾಲ್ಡ್ ಎ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್, ಥರ್ಡ್ ಪರ್ಸನ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ಸಮ್ ಡಾಕ್ಯುಮೆಂಟ್. ಆಗ ಅವ್ರನ್ನ ನೀವು ಎಕ್ಸಾಮಿನೇಷನ್ ಇನ್ ಚೀಫ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಅವ್ರನ್ನ ಕೆಲವು ಪ್ರಶ್ನೆಗಳನ್ನ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ರೀತಿನಲ್ಲಿ ಕೇಳಬಹುದು. ದೆನ್ ವಿಟ್ನೆಸ್ ಟು ದ ಕ್ಯಾರೆಕ್ಟರ್, ಕೆಲವೊಂದ್ಸಲ ಕ್ಯಾರೆಕ್ಟರ್ ಆದಾಗ ಲೀಡಿಂಗ್ ಕ್ವಶನ್ಸ್ ಯಾವಾಗ ಕೇಳಬಹುದು ಯಾವಾಗ ಕೇಳಬಾರ್ದು ಅಂತ 146 ಹೇಳುತ್ತೆ. 147 ಎವಿಡೆನ್ಸ್ ಆಸ್ ಟು ದ ಮ್ಯಾಟರ್ಸ್ ಆಫ್ ರೈಟಿಂಗ್. ಈ ಚಾಪ್ಟರ್ ಮಾತ್ರ ದಯವಿಟ್ಟು ಹುಷಾರಾಗಿ ಓದ್ಕೊಳ್ಳಿ, ಸ್ಟ್ರೇಟ್ ಅವೇ ಒಂದೇ ಸಲ ಓದೋರು ಇದರಿಂದ ಅರ್ಥ ಆಗುತ್ತೆ. ಅಂಡ್ ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ, I think it's already published in Kannada also by somebody. I saw in one of the booksellers, the Bharatiya Sakshya Adhiniyam. All these 3 laws have already been translated and published by somebody. Those who cannot straight away understand in English, there is nothing wrong. We are not born Aristotles or born person with every knowledge. Everyone have to learn it. If you don't understand, please read it in Kannada. And if Kannada version of Bharatiya Sakshya Adhiniyama is not readily available, read the old act itself, because of course lot of things that are there, especially chapter 10, there is no much replacement. Please read. 149 ಯಾವ್ಯಾವ ಪ್ರಶ್ನೆಗಳನ್ನ ಕಾನೂನಾತ್ಮಕವಾಗಿ ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಕೇಳಬಹುದು, ಯಾವ್ಯಾವ್ದನ್ನು ಕೇಳೋ ಹಾಗಿಲ್ಲ ಅಂತ. So this entire chapter of Evidence Act Bharatiya Sakshya deals with how you have to examine, what questions to be asked, what questions not to be asked, wherever there is prohibition. Because this part of the Evidence Act Bharatiya Sakshya Adhiniyama is about the prescription, directory part. Andre, if you cannot do something in the course of examination of witnesses, please don't do it, because you cannot do it, you are not allowed to do it. If you can do something, please read it, how you can do that. and if you can do something to an extent, it is provided what all can be asked, what all should not be asked. Please read it. ಇಂಡಿಸೆನ್ಸ್ ಕ್ವಶನ್ಸ್ ಕೇಳೋಂಗಿಲ್ಲ, ಹೆದರ್ಸೋ ರೀತಿನಲ್ಲಿ ಕೇಳೋಂಗಿಲ್ಲ. ಕೆಲವರು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡೋದನ್ನೆಲ್ಲ ನಾನು ನೋಡ್ಕೊಂಡಿದ್ದೀನಿ. ಹೆದರ್ಸೋದು ಆ ವಿಟ್ನೆಸ್, ಹೇಳ್ರಿ ಎಲ್ಲಿ ಬಂದಿದ್ದೀರಾ, ಎಲ್ಲಿಂದ ಇದ್ರಿ ನೀವು ಅಂತ. ವಿಟ್ನೆಸ್ಗಳನ್ನ ಭಯ ಪಡಿಸೋ ಹಾಗಿಲ್ಲ, ವಿಟ್ನೆಸ್ಗಳನ್ನ ಭಯಭೀತರನ್ನಾಗಿ ಮಾಡೋ ಹಾಗಿಲ್ಲ. ಇವೆಲ್ಲ ಒಂದೊಂದ್ಸಲ ಫಿಲ್ಮ್ಗಳಲ್ಲೆಲ್ಲ ನೋಡಿರಲ್ಲ, ಈ ಕಣ್ಣೆಲ್ಲ ಇಷ್ಟು ದಪ್ಪ ಬಿಟ್ಕೊಂಡು ಅವ್ರನ್ನ ಭಯ ಪಡಿಸಿ ಅವ್ರಿಗೇನೋ ಒಂದು ಇದನ್ನ ಉಂಟು ಮಾಡಿ, ಭಯಭೀತತೆಯನ್ನ ಉಂಟು ಮಾಡಿ, ಆ ಥರ ಎಲ್ಲ ಮಾಡೋ ಹಾಗಿಲ್ಲ ಅಂತ ಕಾನೂನೇ ಹೇಳ್ತದೆ. 157 ತುಂಬಾ ಇಂಪಾರ್ಟೆಂಟು. ನೀವ್ ಯಾರಾದ್ರೂ ಒಬ್ಬ ವಿಟ್ನೆಸ್ ಕರೆದಾಗ ಅವ್ರನ್ನೇ ನೀವು ಕ್ವಶನ್ ಮಾಡ್ಬೋದಾ? ಹಾಸ್ಟೈಲ್ ವಿಟ್ನೆಸ್ ಅಂತ ಅಂತೀವಿ. ಕೃಷ್ಣಾ ದೀಕ್ಷಿತ್ ಸಾಹೇಬ್ರದ್ದು ಒಂದು ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಇದ್ರ ಬಗ್ಗೆ, ಸಿವಿಲ್ ಸೈಡ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ತುಂಬಾ ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟು, ತುಂಬಾ ಒಳ್ಳೆ ಜಡ್ಜ್ಮೆಂಟು, ದಯವಿಟ್ಟು ಓದಿ. ಅದಕ್ಕೊಂದು ಒಳ್ಳೆ ಡೈಮೆನ್ಷನ್ ಕೊಟ್ಟು ಸಾಹೇಬ್ರು ಅದನ್ನು ಬರೆದಿದ್ದಾರೆ, ಪ್ಲೀಸ್ ಓದಿ. 158 ಇಂಪೀಚಿಂಗ್ ಆಫ್ ದ ಕ್ರೆಡಿಟ್ ಆಫ್ ದ ವಿಟ್ನೆಸ್. ಒಬ್ಬ ಸಾಕ್ಷಿಯ ನೈಜತೆಯನ್ನ, ಸಾಕ್ಷಿಯ ಸಂಬದ್ಧತೆಯನ್ನ, ಕ್ರೆಡಿಟ್ ಆಫ್ ದ ವಿಟ್ನೆಸ್ ಯಾವ ರೀತಿ ಅಲ್ಲಿಗೆಳಿಬಹುದು ನೀವು. 159 ಕ್ವಶನ್ಸ್ ಟೆಂಡಿಂಗ್ ಟು ಕೊರಾಬರೇಟ್ ಎವಿಡೆನ್ಸ್ ಆಫ್ ರಿಲೆವೆಂಟ್ ಫ್ಯಾಕ್ಟ್ ಅಡ್ಮಿಸಬಲ್. ಇವೆಲ್ಲ ಬಹಳ ಡೀಟೈಲ್ ಆಗಿ ಇದರಲ್ಲಿ ಕೊಟ್ಟಿದೆ. 162 ರಿಫ್ರೆಶಿಂಗ್ ಮೆಮೊರಿ. ಒಬ್ಬ ವಿಟ್ನೆಸ್ ಕೋರ್ಟ್ ಮುಂದೆ ಕರೆದಿರ್ತೀರ, ವಿಟ್ನೆಸ್ ಮಸ್ಟ್ ಹ್ಯಾವ್ ಬಿನ್ ಕಾಲ್ಡ್ ಬಿಫೋರ್ ಎ ಕೋರ್ಟ್ ಅಂಡ್ ಯು ಆರ್ ಆಸ್ಕಿಂಗ್ ಹಿಮ್ ಎ ಕ್ವಶನ್, ಹಿ ವಾಂಟ್ಸ್ ಟು ಟೇಕ್ ಸಮ್ ಟೈಮ್ ಟು ರಿಕಾಲ್ ಹಿಸ್ ಮೆಮೊರಿ, ದಟ್ ಇಸ್ ಅಲೌಡ್. ಯು ಕಾಂಟ್ ಸೇ ಆನ್ಸರ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಅಂತ ಹೇಳಿಕಾಗಲ್ಲ. ಯು ಮಸ್ಟ್ ಬಿ ಆಸ್ಕಿಂಗ್ some incident which has happened some 10 years 15 years ago. He should give he enjoys the advantage of refreshing his memory. Then onwards 165 deals with production of documents, 167 also. Then 168 judges power to put questions in order put questions or order production. ನೀವು ಮಾತ್ರ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್, ಪಾರ್ಟಿಗಳು ಮಾತ್ರ ಕ್ವಶನ್ ಹಾಕಬೇಕು ಅಂತಿಲ್ಲ. ಜಡ್ಜ್ ಸಾಹೇಬರಿಗೆ ಸಂಪೂರ್ಣವಾದಂತ ಅಧಿಕಾರ ಇರುತ್ತೆ. ಯಾವುದೇ ಕ್ವಶನ್ ಯಾವುದೇ ಪಾರ್ಟಿಗೆ ಅವ್ರು ಕೇಳ್ಬೋದು. The judgments have been written to such extent, even the honorable judge has got power to even put irrelevant questions. ನೋಡಿ ಎಂತ ಬ್ಯೂಟಿ ಇದು. You as a party, you as a lawyer representing a party may not be allowed to put irrelevant questions, because the relevancy aspect clearly says what is relevant, what is not relevant. But the judge's power to put questions includes even irrelevant questions. That's very important. Please read and understand it. Chapter 11 of improper admission and rejection of evidence. Idunu tumba important, ಓದ್ಕೊಳ್ಳಿ. Then chapter 12 deals with repeal and savings. ಇದನ್ನು ಸ್ವಲ್ಪ ಚೆನ್ನಾಗಿ ಓದ್ಕೊಳ್ಳಿ, ಯಾಕಂದ್ರೆ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ 1872 ರಿಪೀಲ್ ಆಗಿದೆ. ಸೇವಿಂಗ್ ಯಾವುದು ಅಂದ್ರೆ ಜುಲೈ 1st 2024 ತನಕ ಏನೇನ್ ನಡೆದಿದೆ, ಯಾವ ಘಟನೆಗಳು ನಡೆದಿತ್ತು, ಯಾವ ಕೇಸ್ಗಳು ಘಟಿಸಿದ್ದು, ಅಲ್ಲಿವರೆಗ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ 1872ನೇ ಅಪ್ಲೈ ಆಗುತ್ತೆ. Now, what is new under the Sakshya Adhiniyam is basically introducing a lot of electronic evidence, electronic records. I am certainly sure that we don't have time today. There is one document which I have in my hand. Tomorrow, I am going to keep a copy of this particular document. It is called Correspondence Table and Comparison and Summary of the Bharatiya Sakshya Adhiniyam. ಇದನ್ನ ಯಾರು ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ವೆರಿ ಬ್ಯೂಟಿಫುಲಿ, ಇದನ್ನ ಸೆಂಟ್ರಲ್ ಅಕಾಡೆಮಿ ಆಫ್ ಪೊಲೀಸ್ ಟ್ರೈನಿಂಗ್ ನವರು ಮಾಡಿದ್ದಾರೆ. ಅನಿಲ್ ಕಿಶೋರ್ ಯಾದವ್ IPS ಡೈರೆಕ್ಟರ್ ಸಾಹೇಬ್ರು ಭೋಪಾಲ್ ಅವ್ರ ಕಡೆಯಿಂದ ಮಾಡಿದ್ದಾರೆ. ವೆರಿ ಬ್ಯೂಟಿಫುಲ್ ಟೇಬಲ್. ಹೊಸ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮದಲ್ಲಿ ಏನೇನನ್ನ ಡಿಲೀಟ್ ಮಾಡಿ ಏನೇನ ಸೇರಿಸಿದ್ದಾರೆ ಅಂತ. ತುಂಬಾ ಸಣ್ಣ ಸಣ್ಣ ಡಿಲೀಷನ್ಸ್, ಏನೇನ್ ಸೇರ್ಸಿದೆ, ಮೇಜರ್ಲಿ ಏನು ಚೇಂಜ್ ಆಗಿಲ್ಲ. ಎಲೆಕ್ಟ್ರಾನಿಕ್ ಎವಿಡೆನ್ಸ್ ಇವುಗಳನ್ನ ಎಲ್ಲೆಲ್ಲಿ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಬೇಕು ಅಲ್ಲೆಲ್ಲ ಡೆಫಿನೇಷನ್ಸ್ ನಲ್ಲಿ ಚೇಂಜ್ ಆಗುತ್ತೆ. ದೇರ್ ಆರ್ ಸೋ ಮೆನಿ ಮೈನ್ಯೂಟ್ ಚೇಂಜಸ್ ಅಂಡ್ ಏನೇನ್ ಚೇಂಜ್ ಆಗಿಲ್ಲ, ನೋ ಚೇಂಜ್ ಅಂತಾನು ಇದರಲ್ಲಿ ಇದೆ ಈ ಟೇಬಲ್ ನಲ್ಲಿ. I would have handed it over to our Gautam Bhai or to our moderator tomorrow through one of my colleagues. This will be there in the Karnataka State Bar Council. ನೀವು ಜೆರಾಕ್ಸ್ ಅಲ್ಲಿ ಹೋಗಿ ಅವ್ರ ಖರ್ಚಿನಲ್ಲಿ ಮಾಡ್ಕೋಬೇಡಿ. Please, if you can spend some money in the photocopying this, please photocopy this and keep it with you. This precisely states what is new, where all it is changed, even the minute comma full stop change ಮಾಡಿದ್ರು ಈ ಟೇಬಲ್ ನಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. ಬಹಳ ಬ್ಯೂಟಿಫುಲ್ ಆಗಿ ಹಾಕಿದ್ದಾರೆ. ಇದನ್ನ ಓದೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಎಲ್ಲೆಲ್ಲಿ ಚೇಂಜ್ ಇಲ್ವೋ ನೋ ಚೇಂಜ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಪ್ಲಸ್ ಹಿಂದಿನ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಮತ್ತೆ ಈಗಿನ ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ ಯಾವ್ದು ಕಾರೆಸ್ಪಾಂಡಿಂಗ್ ಪ್ರಾವಿಷನ್ಸ್ ಅನ್ನೋದು ಸಹ ಇದು ಬಹಳ ಚೆನ್ನಾಗಿ ಇದರಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಬಹಳಷ್ಟು ಪುಸ್ತಕದಲ್ಲೂ ಸಹ ಈ ಕಂಪ್ಯಾರಿಸನ್ ಟೇಬಲ್ ಇದೆ. ಬಟ್ ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ಟ್ಯಾಬ್ಯುಲರ್ ನಲ್ಲಿ ಏನೇನು ಚೇಂಜ್ ಆಗಿದೆ, ಒಂದೊಂದು ಫುಲ್ ಸ್ಟಾಪ್ ಕಾಮನು ಸಹ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಇದನ್ನ ನಾಳೆ ಅಲ್ಲಿ ಇಟ್ಟಿರ್ತೀನಿ. ಆಮೇಲೆ ಸ್ವಲ್ಪ ಹೋಗಿ ಇದನ್ನ ತಗೊಂಡು ಜೆರಾಕ್ಸ್ ಮಾಡ್ಕೊಂಡು ನೀವು ಒಂದು ಕಾಪಿ ಇಟ್ಕೊಳ್ಳಿ. ಅಥವಾ ಯಾರಾದ್ರೂ ಒಬ್ಬರು ನಿಮ್ ಫ್ರೆಂಡ್ ಇದನ್ನ ತಗೊಂಡು ಮಿಕ್ಕದವರೆಲ್ಲ ಆಲ್ ಅದರ್ಸ್ ಕೆನ್ ಮೇಕ್ ಇದನ್ನ ಸ್ಕ್ಯಾನ್ ಮಾಡಿಸ್ಕೊಂಡು ತಮ್ಮ ವಾಟ್ಸಪ್ಗಳಿಗೂ ಇಮೇಲ್ಗಳಿಗೂ ಕಳಿಸ್ಕೊಳ್ಳಿ. ಹ್ಯಾವ್ ದಿಸ್ ರೆಡಿಲಿ ವಿತ್ ಯು, ಬಿಕಾಸ್ this gives a proper insight that what is particular change in the corresponding provision of Bharatiya Sakshya Adhiniyam. Now I conclude my session. I had a great time addressing all my friends on these 5 days, and I am immensely thankful that the opportunity which was given by Gautam Bhaiya and our Harish sir and all the members of Karnataka State Bar Council and the Academy, because opportunity to talk also is an opportunity which is very, very wealthy, which is very, very precious. Not everyone gets this opportunity to be with our friends, and I am so thankful for them having considered me as a person who is fit to give this be with you all for this small interaction. If there has been any errors made by me in these 5 days, I would bow down and please accept my apologies, and please suggest me wherever I was wrong and correct me, because a human being is a bundle of errors. And if have I been a little useful for all of you, my friends, I am so thankful for that. And I dedicate myself to the service of my brothers and sisters, the law students, whenever I have time and whenever I am called upon to do that. And I am so grateful for this 5 days of patience, and I'm also so grateful for making me learn something more by reading it again and again, and by way of your questions, and that has prompted me to learn. And I thank one and all, and let's keep meeting as the opportunity comes again and again. Jai Hind, Jai Bharat.
Thank you so much, sir, for discussing the nuances of the newly implemented law. Now the forum is open for the question answer session. Please send across if you have any questions in the chat box. Sir, for now we just have one question. I'll read it out to you. What are the consequences of an advocate making a false statement without filing any document or affidavit?
See, the lawyers are generally not acting on their own. The lawyers are always acting at the instructions of his clients or her clients. So, any statement made by a lawyer in the courtroom is not a statement made by the lawyer. It is a statement made at the instructions and on behalf of the client, his client or her client. Therefore, the lawyers are never, in fact, liable for whatsoever the statements which are made, even if it is a false or a wrong statement, because he or she, as an advocate, is making such a statement at the instructions of the client. Only if there is an allegation that the lawyer made such a statement without there being instructions, and if it is proved that the lawyer independently made such a statement, then I think it may be a disciplinary action. I don't think it should be inviting a great trouble, but I would only request our lawyer friends to be very, very cautious when making statements in the court, because these days we are often picked on, we are often attacked by the clients. Number of cases in the bar council are going up day by day. Everyone thinks that the moment, see, it is basically like this. As long as the cow is milking, the cow is very good. Once the cow stops milking, then the cow has to be sent to the butcher's home. This happens quite frequently, quite often with the lawyer friends, excepting some circumstances. Therefore, be very careful when taking instructions from your clients. As much as possible, take the instructions in writing, and so that there is very less opportunity for somebody to come and make an allegation on us. So wherever the instructions are not there, by way of writing, see to that the affidavit of the clients are filed. I have seen so many places, even for an interim relief, lawyers are filing affidavits, their own affidavits. We have to stop this habit, because a lawyer cannot file affidavit. He can file memorandum of facts only in respect of certain things. So stop this habit of taking personal interest, personal onus, because it may sometime trouble you. Therefore, be very careful, and lawyer may not be liable for a false statement in the court, because it is not his statement. It's always a statement made on behalf of the client at their instruction.
Thank you, sir. I think that's it. Like, no more questions. Now we would like to conclude the series. I request our president, Sri Gautam Chand sir, to share his thoughts on the series.
A very good evening to one and all. At the outset, I would like to express my gratitude on behalf of Karnataka State Bar Council and Law Academy to Mr. M.S. Shyamsundar, my good friend, Senior Advocate High Court of Karnataka, who has taken out his valuable time for delivering this lecture on New Evidence Act. One thing became very clear from the fact from this lecture that there is not much difference between Old Evidence Act and Bharatiya Sakshya Adhiniyam 2023, except for some electronic evidences. Because it is made clear, otherwise, including advocates and laymen, were afraid. What is this? Whether it is going to make a paradigm shift, the entire evidence law will be changed, and advocates and students will have to study afresh. That apprehension has gone with this great lecture by Mr. Shyamsundar.
There is one thing which I want to say. In the beginning of my lecture, I said we are not yet abbreviating it, because unless and until some court, as the Honorable Supreme Court or some High Court, abbreviates these three new laws, Bharatiya Sakshya Adhiniyam as BSA, Bharatiya Nyaya Samhita as BNS, and Bharatiya Nagrik Surakshita Samhita as BNSS, let us not use. And today, one of our advocate friend, a young lawyer, Kirti Reddy, she has messaged me with so much of dedication, that I think yesterday the Punjab and Haryana High Court has passed a judgment abbreviating this. So, because there is already a constitutional court which has already made such an abbreviated version of these three laws, because every time saying Bharatiya Nagarika Suraksha Samhita may be little lengthy. Therefore, we were waiting for some honorable High Court or a constitutional court to do this work, and so that we all can start following it. Now, since because one of the constitutional courts has started abbreviating, now we can safely say BNS,
BSA.
BNSS, and BSA. So I thank Kirti Reddy for that. I thought I should give that acknowledgement for her.
ಒಂದು ಅಪಿಯರೆನ್ಸ್ಗೆ 2 ಲಕ್ಷ 3 ಲಕ್ಷ 5 ಲಕ್ಷ ಚಾರ್ಜ್ ಮಾಡುವಂತ ನಿಮ್ಮಂತ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಗಳು, when you have readily accepted our invitation, it speaks volumes about your character and dedication to fraternity. ಏನಾಗುತ್ತೆ, ಜನಗಳು you would have spent more than 15 hours on this subject. During this period, giving lecture for 1 hour is not so easy, though you would have done several cases, hundreds of trial cases, dealt with several critical murder cases. You are known for that. Even then, while giving lecture, we have to read afresh.
Yes.
And you have given so much of time. Really, we are grateful to you. ಖುಷಿ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ, ಎಲ್ಲ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ಗಳು ಲೀಗಲ್ ಫ್ರೆಟರ್ನಿಟಿಗೋಸ್ಕರ, ಯಂಗರ್ ಅಡ್ವೊಕೇಟ್ಸ್ಗೋಸ್ಕರ ತಮ್ಮ ಥರನೇ ಒಂದು ಸ್ವಲ್ಪ ಡೆಡಿಕೇಶನ್ ಮಾಡೋದ್ರಿಂದ ಅಲ್ಟಿಮೇಟ್ಲಿ ನಾಲೆಡ್ಜ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡಿಸ್ಪೆನ್ಸ್ಡ್ ಅಂಡ್ ಶೇರ್ಡ್ ವಿತ್ ಆಲ್. ದಟ್ ಈಸ್ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್. ಒಂದು ಸ್ಟೇಜ್ ರೀಚ್ ಆದ್ಮೇಲೆ ತಮ್ಮಂತರಿಗೆ ಏನಾಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಎಲ್ಲೋ ಒಂದ್ ಕಡೆಗೆ ಸರ್ವಿಸ್ ಮಾಡಬೇಕು ಅನ್ನೋ ಮನೋಭಾವ ಬರಬೇಕು. ಅದು ತಮ್ಮಲ್ಲಿದೆ, ಅದು ಮಾದರಿಯಾಗಿ ಎಲ್ರಿಗೂ ಕಾಣ್ತಾ ಇದೆ. Thank you very much. A formal vote of thanks will be given by Mr. Harish. Thank you once again. I will not take much time. We will meet. And moreover, I just wanted to say one thing.
ಹರೀಶ್ ಸಾಹೇಬ್ರ ಅವರೇ ಡ್ರೈವ್ ಮಾಡ್ತಾ ಇದ್ರೆ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಭಯ ಆಗುತ್ತೆ.
ನಾನು ಹಿಂದೆ ಕುಳಿತಿದ್ದೇನೆ.
ಆಮೇಲೆ ಪೊಲೀಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನವ್ರು ಮಾಡಿದಾರೆ ಅಂತ ಹೇಳಿದಾರಲ್ಲ, ಅದೊಂದು ಹಾರ್ಡ್ ಕಾಪಿನೂ ತಗಂತೀನಿ. ಇಟ್ ಬಿಕಮ್ಸ್ ಈಸಿ. ನಾವು ಇವಾಗ ಸ್ಕ್ಯಾನ್ ಮಾಡ್ಬಿಟ್ರೆ ನಾವು ಇಟ್ ಕ್ಯಾನ್ ರೀಚ್ ಥೌಸಂಡ್ಸ್ ಆಫ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಈಸಿಲಿ ಇನ್ ಒನ್.
ನನ್ನ ಹತ್ರ ಇದೆ. ನಾನು ಬೆಳಗ್ಗೆ ಇದನ್ನ ಐ ವಿಲ್ ಸಿ ಟು ದಟ್ ದಿಸ್ ರೀಚಸ್ ದ ಹ್ಯಾಂಡ್ಸ್ ಆಫ್ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಸೆಕ್ರೆಟರಿ. ನಾಳೆ ಕೊಡ್ಬೋದು. ನಮ್ ಕೋಟಣ್ಣ ಬೇರೆ ಬಂದಿದ್ದಾರೆ ಇವತ್ತು, ಬಹಳ ಖುಷಿ ಆಯ್ತು. ಇನ್ಫ್ಯಾಕ್ಟ್ ಆನ್ ಬಿಹಾಫ್ ಆಫ್ ಎವ್ರಿಬಡಿ ಐ ಇನ್ಫ್ಯಾಕ್ಟ್ ಹಾರ್ಟ್ಲಿ ಕಂಗ್ರಾಚುಲೇಟ್ ಅವರ್ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಮೆಂಬರ್ ಕೋಟೇಶ್ವರ ಸಾಹೇಬ್ರು. ಇಸ್ ದ ಸೀನಿಯರ್ ಪರ್ಸನ್ ಅಂಡ್ ಸೀನಿಯರ್ ಫ್ರೆಂಡ್ ಆಫ್ ಆಲ್ ಆಫ್ ಅಸ್. ಬಹಳಷ್ಟು ಸಲ ನಮ್ಮನ್ನೆಲ್ಲ ಕರ್ಕೊಂಡೋಗಿ ಮಾತಾಡ್ಸಿದ್ದಾರೆ. Recognition of somebody is more important than being recognized. ಹಾಗಾಗಿ ಐ ಥ್ಯಾಂಕ್ ಕೋಟೇಶ್ವರ ಸರ್ ಆಲ್ಸೋ. ಅವ್ರು ಇನ್ಫ್ಯಾಕ್ಟ್ ಕೋಟೇಶ್ವರ ಅವನ್ನ ಮೊನ್ನೆ ಕೇಳ್ತಾ ಇದ್ರು ನನ್ನ, ಇದು 5 ಅವರ್ನಲ್ಲಿ ಆಗಲ್ಲ ಶ್ಯಾಮ್ ಸುಂದರ್, ಇನ್ನೊಂದಷ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋಣ ಅಂತ ಹೇಳಿ. ನಾನಂದೆ ಇಲ್ಲ, ಬೇರೆ ಸ್ಪೀಕರ್ಸ್ ಬರಬೇಕು, ಬೇರೆ ಲಾಗಳ ಬಗ್ಗೆ ಮಾತಾಡಬೇಕು, ಇನ್ನೊಂದ್ಸಲ ಮಾತಾಡೋಣ ಅಂತ ಹೇಳಿದೆ. ಐ ಆಮ್ ಸೋ ಹ್ಯಾಪಿ ದಟ್ ಹಿ ಇಸ್ ಆಲ್ಸೋ ದೇರ್ ಟುಡೇ. And lastly, I want to, in fact, thank, before my friend Harish starts, I want to thank our young and cute little moderator who has been patiently with us all along, and she has taken the pains of understanding and introducing everything. And I can see her office still working behind her in the background amid her busy schedule. She has taken to show this dedication, and I thank and I wish a bright future for you, ma.
Thank you so much, sir. It was a pleasure doing this event.
Now you may call upon Mr. Koteshwar to speak a few words.
Sure, sir. Mr. Koteshwara, requesting you to share.
Thank you. I'm very much thankful to the Shyamsundar, a designated senior advocate, who has given valuable time, spent valuable time for the junior advocates, including me. For all the 5 days, I was also one of the student of the. All the 5 days I was there, from beginning to last. Thank you, sir.
Thank you, sir. Thank you. Harish Sahibre.
Very good evening, all of you. Respected Chairman, Vice Chairman, Karnataka State Bar Council, and all other members of the State Bar Council. Shri Gautam Chandi, the Chairman Law Academy, and all trustees of the Law Academy. Shri M.S. Shyamsundar, my senior in the college, designated senior counsel, and all other participants in this law lecture series. As we all know, the new laws have been enacted, and I made a request, and all other members have made a request to Gautam Chandi to start the lecture series. As a part of that, the Law Academy, headed by the Gautam Chandi, has started this lecture series, as we have requested Shri M.S. Shyamsundar to deliver lecture and on 5 long days. Shyamsundar ಅವರು ಬಹಳ ನಮ್ಮ ಮನವಿಯನ್ನ ಸ್ವೀಕರಿಸಿ ನಮ್ಮ ವಕೀಲರಿಗೋಸ್ಕರವಾಗಿ ನಾನು ನಿಮ್ ಜೊತೆ ಇದ್ದೇನೆ ಅಂತ ಹೇಳಿ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಜೊತೆ ಡಿಲಿವರ್ಡ್ ಎ ವಂಡರ್ಫುಲ್ ಲೆಕ್ಚರ್ ಅಬೌಟ್ ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಂ. My sincere gratitude and my pranams and lot of thanks to Shri M.S. Shyamsundar for being participated and delivered lecture on Bharatiya Sakshya Adhiniyam. ನಿಮ್ಮ ಈ ಒಂದು ಸೇವೆ ಬಾರ್ ಕೌನ್ಸಿಲ್ಗೆ ಯಾವಾಗ ಇರುತ್ತೆ ಅಂತ ಹೇಳಿ ಇನ್ನೊಮ್ಮೆ ಪ್ರಣಾಮಗಳನ್ನ ನಾನು ಮಾಡ್ತೇನೆ. ಅದೇ ರೀತಿ ಈ ಕಾರ್ಯಕ್ರಮ ನಡೆಸಲಿಕ್ಕೆ ಬಹಳ ತಮಾಷೆ ಆದ ಕೆಲಸ ಅಲ್ಲ, ಎಲ್ರೂ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡ್ಬೇಕು. ಬಾರ್ ಕೌನ್ಸಿಲ್, ಲಾ ಅಕಾಡೆಮಿ, ಗೌತಮ್ ಚಂದ್ ಅವರು, ಬಾರ್ ಕೌನ್ಸಿಲ್ ಮೆಂಬರ್ಸು, ಗೌತಮ್ ಚಂದಿ ಅವರ ಆಫೀಸಿನ ಸ್ಟಾಫ್ ಎಲ್ಲರೂ ಸಹ ಇದರಲ್ಲಿ ಭಾಗಿಗಳಾಗಿದ್ದಾರೆ. ಗೌತಮ್ ಚಂದ್ ಅವರಿಗೆ ನನ್ನ ಹಾರ್ದಿಕ ಧನ್ಯವಾದಗಳು, ಥ್ಯಾಂಕ್ಸ್ ಅಂತ ಹೇಳ್ತೇನೆ. ಇದ್ರ ಜೊತೆನಲ್ಲಿ ನಮ್ಮ ಬಾರ್ ಕೌನ್ಸಿಲಿನ ಮೆಂಬರ್ಸ್ ಇದ್ರ ಜೊತೆಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರಿಗೂ ಸಹ ಮೈ ಹಾರ್ಟ್ ಫೆಲ್ಟ್ ಥ್ಯಾಂಕ್ಸ್ ಅಂಡ್ ಮೈ ಗ್ರಾಟಿಟ್ಯೂಡ್ ಟು ಆಲ್ ದಿ advocates, learned advocates who have participated in this lecture series. It is to be continued forever ಅಂತ ಹೇಳ್ತಾ, ಇನ್ನು ಶ್ಯಾಮಸುಂದರ್ ಅವರು ಮುಂದಿನ ದಿನಗಳಲ್ಲಿ ನಮ್ ಜೊತೆ ಕೈ ಜೋಡಿಸ್ತಾರೆ. ಮುಂದೆ ನಾವು ಈಗ IPC ಏನು ಈಗ ಭಾರತೀಯ ನಾಗರಿಕ ಸಂಹಿತೆ ಮತ್ತು ಇನ್ನು BNNS ಈಗ ಹೇಳಿದ್ದಾರೆ, ಪಂಜಾಬ್ ಅಂಡ್ ಹರಿಯಾಣ ಹೈಕೋರ್ಟ್ ಏನು ನಾಗರಿಕ ಸುರಕ್ಷಾ ಸಂಹಿತೆ, ಇದ್ರ ಮುಂದೆ ಈಗ ನಾಳೆ 16th ಇಂದ ಪ್ರಾರಂಭ ಆಗುತ್ತೆ. ಇಡೀ ಕರ್ನಾಟಕದ ಎಲ್ಲ ವಕೀಲರುಗಳು ಸಹ ಅದರ ಲಾಭವನ್ನ ಪಡೆದುಕೊಳ್ಳಿ ಅಂತೇಳಿ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಯಾವಾಗ್ಲೂ ಸಹ ವಕೀಲರಿಗೋಸ್ಕರ ಕೆಲಸ ಮಾಡ್ತಾ ಇದೆ. ವಕೀಲರ ಜೊತೆ ಇರುತ್ತೆ. ಕರ್ನಾಟಕದಲ್ಲಿರ್ತಕ್ಕಂತಹ ಎಲ್ಲ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಸು ಮತ್ತು ಇದರ ಬಗ್ಗೆ ಹೆಚ್ಚಿನ ತಿಳ್ಕೊಂಡಿರ್ತಕ್ಕಂತಹ ಇವರು ಸಹ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಜೊತೆ ಕೈ ಜೋಡಿಸಿ ಎಲ್ಲ ಹಳ್ಳಿಗಾಡಿನಿಂದ ಬಂದಿರತಕ್ಕಂಥವ್ರಿಗೂ ಎಲ್ಲ ಉಪಯೋಗ ಆಗುವಂತೆ ಕೆಲಸವನ್ನ ಮಾಡೋಣ. ಒಳ್ಳೆಯ ರೀತಿಯಲ್ಲಿ ಈ ದೇಶವನ್ನ ಮುನ್ನಡೆಸ್ಲಿಕ್ಕೆ ವಕೀಲರುಗಳು ಕೈ ಜೋಡಿಸೋಣ ಅಂತೇಳಿ ನಾನು ಬಾರ್ ಕೌನ್ಸಿಲಿನ ಸದಸ್ಯನಾಗಿ ಎಲ್ರಿಗೂ ಮತ್ತೊಮ್ಮೆ ಹೃದಯಪೂರ್ವಕವಾಗಿ ವಂದನೆಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ನನ್ನ ವಂದನಾರ್ಪಣೆ ವೋಟ್ ಆಫ್ ಥ್ಯಾಂಕ್ಸ್ ಅನ್ನ ಮುಗಿಸ್ತಾ ಇದ್ದೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಭಾರತ್, ಶ್ರೇಷ್ಠ ಭಾರತ್.
Thank you so much, sir. I would just like to give an end note.
Yeah, a special thanks to our moderator Sankirtana. Thank you very much, ma. Thank you very much.
Thank you for giving the opportunity. We thank our esteemed speaker, Mr. Shyamsundar, sir, Senior Counsel, High Court of Karnataka, for spending his precious time with us throughout the week and sharing his immense knowledge and thereby enlightening us about the new evidence law. We are very grateful to have you, sir. Thank you so much again. This academic initiative was a week-long continuous lecture series. This lecture series began on Monday and it ends today. This event was organized under the able leadership of Sri Gautam Chand sir, President, KSBC Law Academy. I thank him wholeheartedly for giving us all of us this great opportunity. I would also like to thank all the individuals who have worked in the background tirelessly to make this series a huge success. Thanks to everyone. We certainly hope that this lecture series has helped all the participants understand the nascent laws better. We hope to see you again in the upcoming events. Thank you one and all for attending today's session and the entire lecture series. Thank you.
Okay, thank you.
ನಮಸ್ಕಾರ ಅಣ್ಣ.
ನಮಸ್ಕಾರ. ನಮಸ್ಕಾರ. ನಮಸ್ಕಾರ ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ.
ನಮಸ್ಕಾರ.